We left off with agenda item 10A, status on update on pending regulations. Did you have more to add to that?
Just relatively quick. I'm not going to go through each one. It is in red in the attachment where each package is. I would like to thank the budget office. They really pushed hard to get the ones that were waiting in their camp approved and through. Unfortunately, we haven't been as successful in the legal office. There's a number of them pending that have been pending since March or April. And we're hoping with the regulation unit, we would be able to hopefully get these through quicker. But I also know that there's one specific reg packet that Dr. Nolan did want to speak about related to alternate route and RVTs.
Yes, it was brought to my attention by multiple stakeholders at a meeting a few weeks or months ago, that the pending regulations that we have voted on, from the board standpoint would alter the current regulations about the alternative route for RVTs. The alternative route does require 2,214 hours, I believe, within a, is it 4,000? Okay, sorry. But anyway, the current regulations don't specify that some of the hours for the alternate route have to be done before the schooling starts. And we have multiple programs in the state of California who have developed, I think, very valuable RVT training programs or schooling programs that encourage students to do them together. So they start their schooling when they start working at the veterinary practice. And it's a valuable training program that does allow more people to become RVTs. So it was something that I hadn't considered when we talked about that regulation. I know it seems to me the initial reason why we did that was because historically the alternate route was supposed to be for people that are out in practice as a veterinary assistant that want to get the training as an RVT. But I think we ought to be aware that if we do continue on with that wording, we may be really decreasing the opportunities for individuals to enter a profession that we really need to build up and support. So I wanted to bring that to your attention. I did attend a meeting at a school, Hancock College, that has a current program that is similar to that. They do allow students to do those hours of training in a clinic, in a practice, alongside their actual classwork. And there were multiple students and graduates of that program that spoke at that meeting that was very compelling. So I just think it's something I wanted to let the board know about, I wasn't aware of when we were passing or talking about that ruling. Now, this is something that has not even been open for public comment yet. So we'll have time, I think, to talk about it, and I'm sure there will be representatives talking about it during public comment. But I wanted to make the board aware of that.
Yeah, and just to give everyone an idea of when that public comment happens, that happens after the whole DCA review. So right now it is with legal and has been since March of 2019. Once that review, there's multiple people through legal. It also goes to the director's office for review and approval. Then it goes to agency for review and approval, and then we can post it. So we still have quite a bit of approvals that we need to obtain prior to posting.
And again, I think it's important that I'm sure that there will be plenty of discussion when it does hit public comment that will help us, so. Any other comments regarding that? A lot of confused looks out there, but.
So nothing to do right now?
No, I just wanted to make you aware of that. Okay, I think we're on item 10B.
Oh, I'm sorry, just one last thing. I do want to introduce our new legal affairs our new legal attorney in the regulations unit, Karen Halbo. She recently started with the reg unit, but she does have, I think, 4 years experience with reg packets, and so she brings a wealth of knowledge, and I'm really excited to have her as part of our team. And I'm really hopeful that, and I know we've already met with her a few times on the status of these rulemaking packets, and she's doing her best right now. But I do know a real high priority for the department is 2138. And so even though we have met with her and told her these are our priorities and these are what we want pushed in the order that we want them pushed, her hands are tied too, because she has to do a whole bunch of other packets for other boards that she's representing. So, but I am really confident with her ability to help us get these through faster.
Welcome.
Okay. So 10B, related to animal drug compounding. So we brought this back again because we wanted to propose some changes for the board to consider in light of the new FDA draft guidance that was provided. And we provided that document for your review. I'm sorry, I'm pulling up the language. Yeah, it's not. Hold on, sorry. Okay. So in light of the changes from, I'm sorry, the draft guidance from FDA, on page 18, we're adding section B, which is compounding. Providing the definition of compounding also means preparing a compounded drug preparation from bulk substances by a licensed veterinarian who has established a veterinary client-patient relationship for the animal patient, or prepares the compounded drug preparation for office stock, or a registered veterinary technician under the direct supervision of that veterinarian, and that is in line with the guidance from the FDA. So if there's any questions or comments on that.
I thought the FDA allowed direct or indirect.
No, their guidance specifies direct supervision of an RVT.
Which
For-
page is that? Any comments or about that?
I'm looking for the.
Any comments from the public regarding that?
Hello. My name is Dr. Zara Hedge. I am the Chief Medical Officer for San Diego Humane Society, and I've been working in animal shelters and high-quality, high-volume spay neuter for over a decade. And I wanted to come up and say that we are in support of the proposed, the draft and the proposed changes. And I just wanted, I know some of you guys may be aware of the rationale for why, but I wanted to share some of that and share some of the resources and reasoning from a shelter perspective and a spay neuter perspective. So the issues regarding compounding with veterinarians in California have been concerning to veterinarians, but particularly shelter vets and those doing spay neuter, because of the volume of patients that we're dealing with on a daily basis. And just to give you an example, at San Diego Humane Society, at our San Diego campus hospital, this past summer, we were performing 60 to 80 or more spay neuter procedures daily, 7 days a week. And so, as you're all aware, in order to provide proper anesthesia and pain control to our patients, we're using multimodal approaches, which is, usually 2 to 4 drugs. And there are a lot of protocols that exist in the literature showing the safety of these, and actually that using this approach, you get to use a lower volume, and it hopefully prevents some adverse side effects. We also know that giving only 1 injection to our patients is more efficient from a clinic flow standpoint, especially in high quality, high volume spay neuter. But also, It's less stressful for our patients because they only need to be handled once. And especially for those of us dealing with a lot of fearful or unsocialized animals, utilizing this type of a protocol is a good fear-free approach for our patients. But currently, it's been a bit of confusion and concern about whether or not we can or cannot mix a bottle of anesthetic analgesic drugs to use for our patients for anesthesia. And not being able to do that is really time-consuming for these clinics and really puts the services we're able to provide at the scale that we're able to provide them at risk. So having to drop each drug individually in a syringe and then administer it right before or as that patient comes in is really difficult, especially when we're dealing with the volume of patients that we're dealing with. And I reached out to several of my veterinary and RVT colleagues that work in shelters and spay-neuter in California, asking them, what are you doing? How are you doing this? And pretty much all of them just said, we're just doing it and hoping that it's okay and we don't get caught. I mean, that's the honest truth. And when I reached outside of the state to similar colleagues, they were actually surprised that this was even something to be concerned about because they've been doing this, they're doing it routinely every day. And I have this, I don't know, I can hand out to you guys just with some resources. But there's been a lot of studies that have showed that these protocols are safe. Oh, thank you very much. Are safe and effective for our patient populations, and we've had thousands of successful cases and extremely low mortality rates to show that. We also deal with a lot of pediatric patients in spay-neuters, some of them less than 1 kilogram, so their dose is extremely small, and it's, you know, there's really no good, safe way to drop drug doses without compounding in a stock bottle. And then I listed on the back of the page a couple of sources citing a few different protocols. Mainly there's one called TT-DEX that has been published and was published by a board-certified anesthesiologist and is used by industry leaders. Thank you. As well as other protocols. And so I just wanted to share that with you and share that we're in support of the changes that you've proposed, and we're happy to help and we want to help in any way possible.
Thank you.
Yeah.
I just wanted to make a note, you asked where it says that direct supervision is required for drug compounding for bulk substances and for everyone. It's on page 10 of the meeting materials. It says, heading number A, compounding pursuant to patient-specific prescriptions. Number 1, the drug is compounded by or under the direct supervision of a veterinarian. That's the first one. And then for office stock bulk substance compounding, it's on page 12. B1, same thing, under the direct supervision of a veterinarian. That's why we had to split out the language, because we previously had bulk substances included under the original definition of compounding, but that allows direct or indirect supervision for that type of compounding because of the FDA draft guidance for bulk substances. We split it out so that it's just for direct supervision.
It doesn't mention anywhere RVTs though, right? You were just extrapolating that.
Correct.
Yeah, okay.
Yeah, because your original compounding, drug compounding regulation only authorizes RVTs to compound.
Can I request this letter to be emailed to us so I can access the hyperlinks?
Yeah, I can do that. And then everything in the hyperlink is cited below, but yeah, it was originally created as an email, so
If you
absolutely.
could email that to me, then I can get it to the members.
Okay.
Thank you.
Great, thank you.
Thank you, Zara. Any other comments from the public?
Bonnie Lutz. I just have a question. Do we know how the FDA defines direct supervision? Because in reviewing all the practice acts in all the states for my client, direct supervision is defined differently in some states than it is in California. So not to throw a monkey wrench into this, but since we are specifically referring to the language that the FDA is using, we just need to make sure that they're defining it the same as we're defining it. so that down the road there isn't an issue.
I don't have the answer to
That's
that.
it. We can research that.
Okay.
So, I'm sorry. So the outcome for this is if the board approves the revisions, then the board would make a motion to approve them.
Was that the only revision that,
The only revision.
okay. When it's not color, it's hard to see.
Do we need to
So we need
wait?
a motion.
Do we need to wait for the answer to Bonnie's
I
question?
don't think so because we have direct supervision in our statute. And I think that you would proceed with our existing statute of how we define it.
Okay, then motion to accept.
So we provided motion language for you in the packets for whoever would like to raise the motion.
I love reading
I'd like
these
to read that,
things.
Mark.
I love reading these things.
Option request.
Well, it starts with please review? No. Where?
Entertain a motion.
A motion to approve?
Motion to approve and then we read all that 45 days.
Then I motion to approve the proposed regulatory changes, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period, and no hearing is requested, adopt the proposed regulatory changes as modified.
Do we have a second?
Second.
Okay. Any discussion from the board? Further comments from the public?
I just have to say, Dr. Nunez, you did a fantastic job. Thank you.
I did, didn't I?
You did.
Good job.
That was well done.
Okay, call for the vote.
Ms. Bowler?
Aye.
Dr. Bradbury?
Yes.
Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Noland?
Yes.
Motion carries. Okay, so the next one is 10C related to informed consent. Members, you have already approved this. However, given the fact that we wanted to wait for telemedicine to take effect, now that it's effective, we felt it was the cleanest if the board re-adopts the language to move forward on the process. And like the others, we provided motion language for whoever would like to top Dr. Nunez.
Okay, any questions or discussion? Any questions from the public? Do you want, somebody want
Oh, I'll-
to make a motion?
I'll
don't have
make
a
the
motion.
motion. I would like to move to approve the proposed regulatory changes, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes as modified.
And boom, there, Mark, look
I
at that.
second it.
Okay, Mark seconds. Any more questions or comments by the board? Any from the public? Call for the vote.
Well done, Ms. Bowler. Ms. Bowler?
Yes.
Dr. Bradbury?
Yes.
Ms. Laredo? Oh, sorry, I don't have a crossed off. Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Noland?
Yes.
Now we're rolling.
Can we vote now on who wore it better?
Who read it better?
Who read it better?
We're not done yet.
Oh, boy.
You
All
will.
right.
So the next one is 10D. Members, as I've been updating you on 2138, as you can recall, The language that was previously proposed to the board was the work from the DCA Legal Affairs Division. They work closely with OAL and the Attorney General's office in crafting that language. However, by the time it got to OAL, the OAL people involved and the Attorney General's office people involved had since retired. And so DCA, there were new people involved in DCA, worked with OAL again because OAL had a number of concerns with the language in 2138. And so legal worked a lot on what is considered the solution to address their concerns. And we're pretty confident after this new revision that this would get approved through OAL. I personally need to thank Tara because she's not only leading the charge for us, but for all of DCA, because we were the very first ones to get this packet through. So we're basically the guinea pigs on it. And when they came down with their concerns, Tara has been rocking it and going back and forth and fighting many battles on this. So I want to thank you for that. But then I will, there's a catch-22 to that because I'm going to turn it over to you to go over the revisions.
Okay, so some of the changes that we've worked out with OAL are minor and non-substantive, and others they're characterizing as substantive. So I'm going to primarily focus on the substantive revisions. So I'm on page 6 of the modified proposed regulatory language. First off, under substantial relationship criteria, this is existing section 2040. These are the criteria to be applied when the board is reviewing either an application or a disciplinary matter that involves a criminal conviction or professional misconduct in another state or jurisdiction. You may have seen these, especially with the crimes. The crime has to be substantially related to the practice of veterinary medicine. So that's what this code section refers to. How do you apply substantial relationship in those instances? So what we're doing here in subsection A is we're going to add section 4883 subdivision N as a cross-reference here. So we're maintaining the board's existing authority to apply substantial relationship criteria to professional misconduct of a licensee or registrant in another U.S. state or territory. That's similar to what's provided under section 141 of the code. But that 141 is actually a bit broader because that also applies to professional misconduct in foreign countries. So we're just, belt and suspenders, making sure that the board properly applies substantial relationship criteria to all of the appropriate causes for discipline or denial. We're also clarifying, for purposes of this section, what is a license, because the board issues licenses, registrations, and permits. And OAL noted that this rulemaking package only uses the term license. And, when I look at the authority and reference sections of both of these CCRs, I see that the only cites are to the General Business and Professions Code. And under the General Business and Professions Code, it does define what a license can be for each different board that is provided under the Business and Professions Code, and that does include registrations and permits. However, just to be extremely clear about what this applies to, we've been asked to include a definition of license to also mean registration and permit. So we've included that sentence here. Under subsection B, we've made some minor technical revisions. I'm going to keep moving forward here. And by the way, I'm really only discussing the revisions that appear in double underline or double strike through because those are the modifications that you're reviewing today. Everything under a single underline or single strike through is something you've already approved. Okay, so under Section 2041, Criteria for Rehabilitation on page 7 of the meeting materials, these are the criteria that the board applies for application denials and discipline to determine whether, even though there may be a crime or professional misconduct or other act warranting discipline, has the applicant or licensee shown the board that they are rehabilitated from the unlawful act or conduct. So because the board and the legislature is interested, primarily the legislatures, they're interested in reducing barriers to licensure. They want to make it, I wouldn't say easy, but they want to provide opportunity for individuals to show that they have changed their lives, they are rehabilitated, they will no longer be participating in unlawful conduct. So we are including in this section all of the types of misconduct that the board will apply rehabilitation criteria to. The board already does this when it reviews disciplinary matters and application denials, but 480 restricted, or rather 2138 only requires the board to apply rehabilitation criteria for denials under section 480, which are the crimes and professional misconduct, or discipline under 490, which is criminal convictions. But your Practice Act includes several other types of misconduct that are subject to discipline. So we want to make sure that this board is applying rehabilitation criteria evenly to all applicants and all licensees to provide them the opportunity to prove to the board that they are safe to practice. So, having said that, once again, we are defining what a license is for purposes of criteria for rehabilitation. You'll note that unlike Section 2040, Section 2041 only references purposes of subsection C and D as defining what a license is. That's because subsection E is specific to petitions for reinstatement under Business and Professions Code 4887, which does not currently reference permits. So OAL requested that we limit the definition of license in this instance to just subsection C and D. Subsection B defines who is a licensee. This would mean a licensee, registrant, or permit holder. Subsection C begins, this is the provision for denial of a license. So paragraphs 1 and 2 only apply when the board is reviewing an application and whether or not to deny the license. We've made minor technical changes to paragraph 1. I know it looks like a lot, but it's really just clarifying. The biggest substantive revision that we've made here is to paragraph 2. And this was necessary and requested by OAL to better clarify the circumstance under which the board would be applying rehab criteria for applicants. So you'll notice that paragraph 1 applies to criminal convictions And paragraph 2 applies to all others. So it could be criminal convictions where the criminal sentence has not been completed, or the denial is based on professional misconduct, or the denial is based on one or more grounds under the Practice Act. So with those clarifications, most particularly listing all of the different Practice Act sections, OAL determined that this was substantive but necessary. We're also going to be adding reference to professional misconduct under subparagraphs A, B, and C. So we're making similar changes for applying rehabilitation criteria for new subsection D, suspension or revocation of a license. So you'll see very similar language, similar changes. Most particularly under paragraph 2, we're listing different code sections, which are the grounds for discipline, not denial. And instead of professional misconduct, we're going to be referencing disciplinary actions in subparagraphs A and C. And then in subsection E, we're making a clarifying change to strike Government Code Section 11522 to instead refer to the petition for reinstatement requirements under the Practice Act, which is Business and Professions Code Section 4887. That's it.
Before you all get excited about the super short recommendation, who's going to do it? That's actually, it's a different motion, and so Tara has that language. I didn't have it in time to put it on the item, but it's a 15-day comment period because it's already gone through the regular process. It's a shorter motion or different motion, so I gave it to Tara. Sorry, guys.
Could I ask a question? Or before the, is this, given Tara's work with the other boards and with the legal department, is this the template for all the boards as far as 21?
Yes.
The bill is concerned?
Some of the other boards may make tweaks to this language appropriate for their purposes.
Okay.
But yeah, this is effectively the template that we're pushing forward for the other 39 boards.
Okay, 2138, okay, thank you.
So anybody want to volunteer to make the motion?
I've got the
That Tara's
motion.
going to
Tara's
read for
Tara's
you?
gonna have to-
do that one.
I'll make a
Well, I mean,
motion.
So can you read that for her then? So this would be
Bradbury?
Christine's motion. Or was it Alana?
I don't have to say much, so that's good.
Okay,
Oh,
so
we'll do that in just a minute. We're going to read this and then.
Dr. Bradbury moves to approve the proposed modified text for a 15-day comment period, and if there are no adverse comments received during that 15-day public comment period, to delegate to the executive officer the authority to adopt the proposed regulatory changes as modified, and also delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
Do we have a second? Anyone?
Second.
Okay, Kathy, second. Any questions or discussion? Mark?
This was a rather shocking piece of regulation when it first came to us, because I had concerns
Yeah.
about it, but
Yeah.
I'm quite pleased at what Tara has done with it. So, thank you, Tara.
Kudos. Public comment?
Bonnie Lutz. First, yes, I will tell you, Tara, having read through this, it's a fabulous job, and I can totally understand how much time you put into it. My issue is, however, having read the entire thing, I don't see any definition of professional misconduct. And that's very concerning to me because there is no current definition of professional misconduct. And so I'm concerned.
Okay.
Because that could mean a lot of different things to a lot of different people.
So I'm just going to refer you to Section 480 which uses the term professional misconduct with no definition. So we are tapping in on 480 as required under 2138. We're just saying this is professional misconduct under 480. Because if you'll notice, the Practice Act uses the term unprofessional conduct.
Yes.
It doesn't use professional misconduct. So at OAL's request, we are inserting professional misconduct as that term is used under Section 480.
Even though it's not defined.
Correct.
I mean, okay, so all I would say was I can understand the thought process there, but in order to look forward at having a practice act where we can actually figure out what's meant by some of these words, I mean, it would seem to me that would make some sense to define it. I understand that you're dealing with another agency and that that's part of it, but I mean, this is what happens, it appears, with legislation, is that, you know, down the road, all of a sudden, we have a situation and we're trying to define professional misconduct, and maybe you're all gone. You know, there's no history. And, you know, who knows what it is? So then it's up to anybody to just make up what they think professional misconduct is. Despite the fact that it's in the Practice Act, it's not defined. So it would just appear to me that it would be, since you're using it over and over again in 2040 and 2041, and 2040 and 2041 are pretty serious statutes as far as what can happen to a licensee based on those statutes, it appears to me that you'd want to define it further. Because it's really not a real clear term to a lawyer.
I've had
you. I think
assurances that Tara will still be here when we're all gone.
I don't know about that.
I've got her for at least 5 years, I said.
You know, I think you're right. I think you're right. It's obviously not something we're going to do today.
The other comment then is, and I know I wasn't supposed to comment on things that were just singular underlines, but if you go back to 2040C, again, and where professional misconduct is used, and, you know, I love that including but not limited to language, as we discussed yesterday. Generally, I love that language. But what C looks to me like is that it's an open-ended ability for this board to go after a veterinarian, again, because of the use of the term professional misconduct, which is not defined, and then including but not limited to language. So it appears that 2040C gives you open-ended, almost overbearing ability to go after a veterinarian for whatever you want to go after them for. So it seems overreaching to me, especially since professional misconduct is not defined.
And for risk of sounding insensitive, it's not just going after a veterinarian, it's going after a veterinarian with a criminal conviction.
I know, but criminal convictions, you know, I mean, I've dealt with criminal convictions. I mean, some of them, you know, some of them are 647s, you know, some of them are drunk in public, you know, some of them are DUIs, some of them are more serious, but in 20 years of practicing, I've only had one that was like a felony physical violence, spousal abuse case. All the rest of them have been DUIs, 647s in college.
What's 647?
647 is a drunk in public.
Oh.
So, I mean, I'm assuming that a lot of people get drunk in publics in college, so that's my concern, is the overreaching.
We just learned a lot about you, Bonnie.
We all have a history. I just want to point out that that is merely, I would argue, a restatement of the existing law. If you'll look up under subsection A.
Right, and I saw that.
Yeah.
Yeah.
At the end of that paragraph, it strikes out such crimes or acts shall include but not be limited to those involving the following. We're inserting a bunch of language, but that's ultimately the beginning of subsection C.
And I
So,
understand that, but
in
what
that
I'm saying is
respect-
the term professional misconduct. That's my concern. is the
Professional misconduct is-
Professional misconduct term.
Yeah, it's only used in 480.
Okay, well.
And we
anyway,
are
that's my concern.
cross-referencing 480. So, and we're being required to add it by OAL, so it's, I mean, we had that
Okay.
discussion.
So I know that I motioned. and I still motion, but I just.
You did a fantastic job, by the way.
Thank you. On the first page of the memorandum, it said that they asked us to, it looked like it, to include a definition of professional misconduct, to clarify the difference between professional misconduct in BPC 480 and unprofessional conduct. Is that what they asked us to do? And so you did that in here, you feel it's, oh.
No, that's why those are the concerns they raised right before we withdrew the package. So for the next 2 months, we negotiated language and ended up with this language. This is where we arrived.
And they're fine with this.
Yes.
Did Diane have?
Well, no, I was just reading now.
Can you speak closer to the mic?
Oh, yes. I was just reading now 480 and then also reading 4883 when there's unprofessional conduct, which is like a little bit more defined. So it's just, I mean, it's one of the things where we have two different undefined, so it almost would be easier to, because professional misconduct isn't defined at all in 480, it's just mentioned, but unprofessional conduct is more defined in 4883 G.
Right.
So, but I don't know if we wanted to then make this unprofessional conduct to have it a little bit more defined. Does that, but I don't know if that's what then the OAC asked us to do.
Cheryl. So Tara, are you saying that OAL says this is language you should use and this is the only one they're going to accept?
I'm sure in a perfect world, we could have somehow come up with a definition of professional misconduct to meet the standard of 480, but we would also had to come up with a second definition for unprofessional conduct because two different terms are being used under the Business and Professions Code that apply to this board. So 480 uses professional misconduct. We're stuck with that. We are required under 2138 to provide substantial relationship criteria for professional misconduct cases. So we've added that. You'll notice that 4883G does talk about unprofessional conduct, but in substantial relationship criteria, we're only referencing 4883N, which is misconduct in another U.S. state or territory. So with that cross-reference, we continue to limit the application of substantial relationship criteria to only criminal convictions and professional misconduct through formal disciplinary action in another jurisdiction. We're not talking about substantial relationship criteria applied to unprofessional conduct because there is no requirement to apply substantial relationship criteria to all unprofessional conduct. You'll notice that when you see substantial relationship criteria in the code sections, it's always about a criminal conviction or formal discipline in another jurisdiction. Because the legislature is saying, you have to look at this conduct and make sure that it actually applies to this professional practice. Unprofessional conduct under the Practice Act is a violation of the practice of veterinary medicine. But when we're talking about a criminal conviction or professional misconduct in another state, we have to double check it to make sure that actually has relevance with respect to the practice of veterinary medicine. Does that help?
Grant? Grant?
It helps me educationally. It still doesn't make me feel better about this language. Grant Miller, CVMA. So we're very concerned about the not limited to portion of this. And as you will probably recall, we have brought up concerns in the past about unprofessional conduct being used to describe many violations from licensees who are being investigated by this board, because when you look at 4883, really unprofessional conduct looks very much like substance abuse, diversion, things of that nature. And so this professional misconduct is actually a kind of a good idea because there are so many other violations of the act that can occur that are really not what we're calling unprofessional conduct based on 4883. The concern here is, though, that when you say is not limited to, really, when we look at this, the jurisdiction of this board is within the binding of that book that you have. It's the Veterinary Medicine Practice Act. So to me, okay, the definition of this would be a violation of the Practice Act. And we know that there's a special set of violations that constitute unprofessional conduct. We know that a violation to 2038 is unprofessional conduct. Violation to VCPR 2032.1 is unprofessional conduct. There are a number of places where it's specifically called out in the Act. And then, of course, everything relating to 4883, it's titled with, unprofessional conduct. So, okay, those are special for those circumstances. But everything else could be professional misconduct if it were defined as such in 2041. So, Tara, when you look at 2041 as it's written now with subsections 1 and 2, Section 2 is conviction of a crime involving fiscal dishonesty. That's described in BNP 480.
And you're talking about section 2040?
Yes.
Okay.
Yes. I'm talking about your proposal here, what you...
Right. I think you said 2041, and we got to be clear because they're completely different applications.
So, I'm sorry, it's 2040, but it's section C, 1 and 2.
Okay.
So down just a little bit more. There it is. So why not say professional misconduct shall include violations to BMP section 480, makes DCA happy. It also gets rid of number 2 because conviction of a crime involving fiscal dishonesty is listed in 480, and then round it out with violation of other state and federal laws governing the practice of veterinary medicine. That's the book you have in your hand. Why not that way? Why not define it that way?
Define professional misconduct to
Yes.
mean?
Violations of BNP 480 or violations of state and federal laws governing the practice of veterinary medicine?
So where in the Practice Act does it say professional misconduct?
Well, this would be the first place it would say it.
Right, but professional misconduct is in 480. C says for purposes of A, which is when do you have to apply substantial relationship criteria? And C says you have to apply substantial relationship criteria for crimes, professional misconduct, which are, it's formal discipline in another jurisdiction, or acts that shall include but not be limited to violating or attempting to violate the Practice Act or other state and federal laws governing the practice of veterinary medicine. If we define professional misconduct here in the way that you're saying it, then what do we do with unprofessional conduct? That was the whole point of OAL. We've got two separate terms because we had no ability to participate in the drafting of 480. So now we're stuck with two different terms that we're trying to create a template that would be used by 40 different boards. And 40 different boards potentially have professional misconduct and 480, or they've got unprofessional conduct like we do. So we were trying to keep this extremely tight so that there's consistency among the regulations of all of the boards. So that's an overarching goal, is to create a template that everybody can use. So we're only referencing professional misconduct and substantial relationship criteria to satisfy 2138 and its reference to 480. We're not trying to redefine unprofessional misconduct or unprofessional conduct and how that relates to professional misconduct and how that term is used under 480. I mean, we're trying to keep this simple.
Right. So along those lines, if you're trying to comply with 480, which makes one mention of professional misconduct, why not remove C from this altogether? Why do you need it? Because C is a definition of professional misconduct as it's written.
Well, I would say that it includes acts. It's not just a definition of professional misconduct. Professional misconduct as used in 480 is specific to formal discipline in another jurisdiction. It does not include unprofessional conduct under our Practice Act. And that's what or acts in subsection C does.
Okay, so if it does those two things, then why is the is not limited to in there?
Because it's always been in there. And all of the regulations that speak to substantial relationship criteria have included that language because of the stricken language at the end of subsection A. Such crimes or acts, which never referred to professional misconduct until 480 came along with professional misconduct, such crimes or acts shall include but not be limited to those involving the following. What's listed under new subsection C. And again, we're trying to maintain consistency with all of the regulations that talk about substantial relationship criteria. And when this was first written and then implemented, all of the boards had the same language. So we're trying to
I see what you're trying
craft
to
it
do.
for everybody.
I'm sure the board can understand why, as a representative of licensees, why we are very concerned about grounds for denial, suspension, or revocation on a not limited to basis. That can be a lot of stuff that we might not even know the rules of that playing field. So right now, we know we have to apply to the Practice Act. You know, here it is, the Veterinary Medicine Practice Act is what governs us. It shows our rules. But when something like this comes in, we don't know where that begins and ends. But I do understand now much better what Tara's trying to do. I think this BMP 480 is useless. I mean, this thing doesn't have, it's challenging to decide how this gets incorporated in, unless you just make a blanket reference to it and say for purposes of this subsection, it apply, you know, everything in 480 applies. That makes DCA happy. And by the way, you're subject to everything in the Practice Act. There's the world that you have to live in as a licensee. That gives us 4 square corners.
I would say that this is limited.
So then we can remove the is
No.
not limited to?
No. Well,
Keep
Can
trying,
I just
Grant.
say, I mean, just because there's bad language in a regulation, this is so frustrating to me because, you know, if there's language in a regulation that none of us can understand, and we're just going to keep the same language despite the fact that we don't really need it and don't really understand it, I find that very frustrating. I think, you know, if you have the opportunity, like you have here, to actually clean something up, then it would seem like it would make sense to do that. Now, the other thing I was going to say, though, is, Tara, when you were just talking and describing what professional misconduct, you said professional misconduct, what did you say? Something about something in another state?
That's
You
$480.
were keying it. I know.
It's $480.
I know, but even more so then, if it does have to do only with something in another state, then, as Grant suggested, refer back to 480 and leave out the, but not limited to.
Well, 480 also talks about fiduciary dishonesty, which we have there in
Right.
C2.
Or just leave out the whole paragraph.
So,
well, if you look at A, it says, for purposes of denial, suspension, or revocation of a license pursuant to Section 141, which is discipline in another jurisdiction, Division 1.5 commencing with Section 475, which includes crimes and professional misconduct under 480,
got it.
or Subdivision N of 4883, which is the Practice Act formal discipline in another U.S. state or territory. That's it. That's our reference to 480. There is no other reference to unprofessional conduct in that clarifying provision.
So what you're saying is that the but not limited to is there because in other states, in other jurisdictions, there may be other violations that are not necessarily termed professional misconduct that you have to take into account. There may be grounds for disciplinary actions in other states based on their laws that you have to consider here. Is that why? What are you trying to catch with that is not limited to?
I'm trying to maintain existing law.
Okay.
Because
All right.
it's what everyone has.
Okay.
So if we strike, but is not limited to, we're now creating our own limitation, which if you guys want to do that, that's fine. I hear you suggesting that, which I get, because otherwise, this is already including everything under the Practice Act and in other jurisdictions relative to the practice of veterinary medicine. So what else is there?
Yeah, and
Right?
what I would say is, what I would contend is you're not creating your own limitation, you're defining your existing limitations, because there are limitations of this board. It's a board of administrative law. So to me, the limitations are what's in that book, which you have written. You have that, other state and federal laws governing the practice of veterinary medicine. So I get what you're trying to do. I do.
It's worse than that, because, we have a deadline that we are trying to meet, and if we strike language here, and I try to take it back to OAL in 2 or 3 months after it gets through final review again through agency and a 15-day public comment period, and they continue to have problems,
Yeah.
it's going to have to come back to you guys.
Well, I think that our concerns are made clear to this board, and that's why you guys are up there, so thank you.
Okay, thank you.
So what do you think about striking, but is not limited to?
Christina?
I want to withdraw my,
No, don't withdraw.
no? Well, I actually,
I was going to ask if you wanted to amend your proposal with striking out is limited to, or is not limited to.
and because it means that we're making substantial changes, so I don't.
That's what Tara says, yes.
I'm saying
But-
that I'm putting all the information out there.
Of
I'm
course.
not saying I disagree with it.
No.
And I don't mean to shut conversation down about this issue, okay? Okay.
It's educational for us as well.
But
Yeah.
well, what Grant's saying makes a lot of sense to me, that it does encompass everything that we need to have in there without having that, but is not limited to in it. I mean,
So do you withdraw your motion?
I withdraw my motion.
Then I'd like to make a motion.
Here, so Cheryl?
So back to OAL. So if we try and change this language, because you've been negotiating them for 2 months already. So if we change this language that goes back to AOL, what are they going to say? Are they going to say, no, you have to go back to the language we had to begin with?
They could raise concerns about the new revisions. I don't know what those concerns are going to be. I didn't expect any concerns with what we had presented to them, because the AG's office, Legal Affairs, and OAL had already signed off on it. And then suddenly, OAL is reviewing it suddenly for the first time, and we have all of these concerns. So I honestly don't know what they're going to do, but I'm not saying that we shouldn't revise it.
What's our deadline?
July 1, 2020, it's supposed to be effective. I think our deadline to get it back to OAL is like May, because there are so many 2138 packages that are going to land on their doorstep.
What are any of the other boards that you are the attorney for? Are they having to?
Oh, yeah.
this too?
Everybody
And
is
is
pretty
somebody
much
else
having to
bringing up
revise
this-
it.
Any other boards bringing up this issue?
This is the first I have heard of this concern.
Okay.
And we also argued to OAL that there were no public comments brought up in any discussion of 2138. And now we have public comment raising concern with it. So,
I think Kathy has a comment.
Well, part of it is sort of an offshoot from Cheryl's. It seems to me, and I very much understand what Grant's saying. The open-ended portion of that must have some, aren't there other effects to other licensed practitioners? I would assume if this is like the template, that other people are going to bring the same issue up, and so that maybe if we did amend this, it wouldn't be such a extraordinary amendment if other licensees are going to be bringing up the same. Now, I realize our code sections that we're dealing with are different than others, but I assume the same concept would still be there, Tara, and I don't know, because I don't understand how locked in all of this is.
so I'm trying to research quickly some of the other boards and their substantial relationship regulations to see how they might have tweaked prior language.
Yeah, well, I can appreciate wanting to have an overarching thing that is such a extraordinary piece of work. I think we have to think about what's best for our board and the veterinarians. So I do worry that this is rather open-ended, and I wouldn't have noticed that. So thanks for bringing that to our attention.
So here's one. We've got accountancy. Section, it's 16 CCR 99. Such crimes or acts shall include but not be limited to those involving the following: dishonesty, fraud or breach, fraud or deceit, gross negligence, violation of any of the provisions of their Practice Act. So that has been a consistent use of the term. I know it has, that language continues in the 2138 language. I think you could strike the language. I can't guarantee any result with it. That's all.
We have to remember the driving force behind this regulation is to lower barriers to licensures. By striking out is not limited to is going to advance that cause. So the powers that be that are behind this are probably not going to have too many concerns about it. And if OAL does raise concerns about striking that language, I think we have responses to it on that professional licensure or professional misconduct as it relates to veterinary medicine is covered in our Practice Act, is covered elsewhere.
Karen has a unique insight into the 2138 issues because she's been reviewing several of the other boards' packages.
Great.
Can you help us out?
Well, I just wanted to say, we were struggling this with the Physician Assistants Board and looking over the language, and our understanding at this time is there's no guarantee that this language, we're not encouraging other boards to make changes based on this at this time, because if a different reviewing attorney at OAL gets assigned a package, they will have different preferences and different levels of pickiness. I don't want to speak to what this board wants to do, but for the PA board, the issue is our board's mandate is protection of the consumers, not necessarily of the licensees. And that while it does seem like it leaves extra powers, that's the point. You're the board. You're the protection for the public and the public's animals. So having sat through the PA boards arguing about it, that's where they headed. But I gather these are very credible people and are trying to explain to you their concerns, and you're really trying to balance a lot of issues. But I wanted to let you know, the other boards are not being encouraged to take this and run with it because we don't know, but we know that we have a promise that this should work. Now, given that we had a promise before the other should work, I would say, please don't touch anything. That's just my opinion, because I'd like to get these through by the deadline. So,
Yeah. And could you state your full name for the?
Karen Halbo.
Yeah, thank you.
Thank you.
Before Karen spoke and after Christina, I was just thinking that sort of the same thing from a consumer consumer protection perspective, which this board is, and the fact that we are under the timelines here. I agree that there's some concerns from the licensing community too, but I have to remember what we're also here for, is to protect consumers and to protect animal patients. So I want to be cognizant of that from my point of reference here.
Thank you. Any other comments? Any other comments from the public? Currently, we have no motion that I know of.
No, because Dr. Bradbury withdrew her motion.
I believe so.
Then I am going to make a motion to accept this language with the words "is not limited to" crossed out.
So to be clear, you're saying on page 6, in subsection C, second line, you want to strike,
But is not limited to.
got it. So it just reads, shall include the following. Okay, so to be clear, let me go ahead and read the 15-day script.
Well, no one's seconded yet.
That's fine. We need to be clear on what your motion is. The motion is to approve the proposed modified text as amended for a 15-day comment period, and if there are no adverse comments received during that 15-day public comment period, delegate to the executive officer the authority to adopt the proposed regulatory changes as modified, and also delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
I second that. Can I make another comment too?
Yes.
I just want to say that I still think if we really stand behind our Practice Act, the way that we've written it, then I think that is still fully protecting the public. So I second that.
Any other comments by the board?
Just accepted the amendment.
Public comment?
I just want, so other people will vote yes.
Call for the vote.
All right, Ms. Bowler.
No.
Dr. Bradbury.
Yes.
Dr. Nunez.
Yes.
Ms. Prado.
Yes.
Dr. Waterhouse.
No.
Ms. Yanis.
Yes.
Dr. Noland.
Time for a bathroom break. No.
It is 4 yes and 3 no. The motion carries.
Can I ask a question procedurally? And I don't know that there's a way. I know we have, our next meeting is in April. If Tara, if this goes forward, we have the 15-day, et cetera, and we get some clear guidance from OAL and the rest of the sort of folks, what will pass and what will not pass. Is April our deadline to have something ready for the July? I mean, we're still up against the July deadline, correct? And I'm just wondering what options we have if they may accept this, and this may be fine, and the 15-day period may come and go. But if it isn't, what's the next step?
I think we're probably going to have to float the language to OAL. You may need to have a teleconference to discuss the language if it's not acceptable by OAL. April, I believe, is too late because of the subsequent review process through DCA and agency
Yep.
with a potential 15-day public comment period if you make substantive revisions in April. So I think, yeah, if you needed to change the language, you'd have to do a teleconference.
But they still could accept it.
They could.
Right. That's only if, if I can get clarification through OAL whether or not they would accept this amendment. And then it's, crossing fingers and holding my breath. But I want to do the will of the board, so I'm not fighting it.
Okay, we'll move along to item E.
Okay, so item E is related to section 2043, and it is what we use when we consider issuing citations. However, after reviewing it, and it is limiting our ability to issue citations to only things that occur while engaged in the practice of veterinary medicine. There are a lot of other violations that could happen that's not technically while engaged in the practice of veterinary medicine. The statute itself does not limit it. We put this limitation on ourselves. I think there are a lot of things that we could be issuing citations for that don't warrant discipline, that it's a better way to resolve the issues. For example, if they did not do CE and it was a minor violation, depending on the case, if they completely didn't do anything, that's a different story. But if they were, if they didn't comply with that, if they had minor probation violations that might not have been specifically well engaged in the practice of veterinary medicine, if they don't respond to a records request from us, that's a violation, not maybe technically part of while engaged in the practice of veterinary medicine. I just think that this really ties our hands, and I think we should really consider striking this. Another example would be a criminal conviction that doesn't warrant discipline, but we don't want to just close the case, and that's the options that we would have right now. And so I highly recommend striking this because the statute itself doesn't put this limitation on, and it's a valuable enforcement tool that we would be able to use and save costs in the long run of either having the option of closing the case or pursuing discipline. So.
Okay, questions? Comments?
Motion to accept.
Any
I'll second
questions or
that.
comments?
I was going to clarify, I want to clarify, our limitations on our board are unusual compared to the other boards, is that correct, in the citations?
In many ways, but this one, yes.
Oh, we're unusual.
To make it that specific limitation, yes, is unique. And just to clarify, Dr. Nunez, I did provide actual motion language for this if you do want to accept it.
Oh. Okay, I think this is very good.
That's not what she wrote.
I'd like to motion to approve the proposed regulatory changes, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make all technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes. And do I have to put as modified? Because we didn't modify
You
it.
modify it.
Okay,
I second that.
well done, Dr. Nunez. Second, Dr. Waterhouse, Waterbury, or what do we call it?
Waterbury.
Any more comments or questions? I have a question for the public. Is this going to in any way help us with cite and fining unlicensed activity?
So that's different because there's a specific carve-out for unlicensed practice. It's automatically a Class C $2,500.
I see that.
So this wouldn't impact that at all.
Any questions or comments from the public? Okay, call for the vote.
Ms. Buller?
Yes.
Dr. Bradbury?
Yes.
Dr. Nunez?
Aye.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Noland?
Yes.
Motion carries.
Jamie.
Now we're to.
What time is it? We're going into regs then, right? What?
It is now 3:16. We will reconvene at 3:25.
Okay.
It's 9 minutes. Being brief with your break, I appreciate it, and we're going to go ahead and move on to, I did want to announce that because of public comment and whatnot, we are going to push back item number 9 on the agenda to the end of the day if we have time, or to tomorrow, if more likely. So, yeah, so we're going to move on to item number 11, and I'm going to
Yeah.
turn the.
So members, agenda item 11 was more so as placeholders for the board to be able to discuss if legislation was brought forward. And when the time that this was posted, there have not been any changes, which is why you don't see many materials before you. As you know, we'll just jump into animal blood banking legislation. AB 366 and SB 202 were the two competing pieces of legislation. AB 366 was withdrawn earlier on in the process, and as you know, SB 202 made it to the governor's desk, where he sent a pretty strong veto letter, and he was pretty clear on where his stance was as it relates to animal blood banks. After that, we have been in contact with the governor's office, with CDFA, with CVMA, the sponsors of both bills, and everybody seems to be interested in solving this issue. The main concern that I've had is how this is going to be regulated and what the future holds for animal blood banking and what it looks like. There's been some questions from the governor's office and some push for the board to start regulating this and take it away from CDFA. And I will hear from the stakeholders here, depending on how they see that operating, will drastically impact if this board is going to do it, how they can do it. I'm not sure if that's appropriate for this board to take this on, but also just pure logistics. As you know, we are struggling as it is. We don't have the funds to do this. CDFA is in a different situation. They are funded from various sources, including federal, state money, and some special funds. We are solely special funds, so any change to us is going to go on the licensees. So the difference, though, if you create a separate license, then it would need to cover all of the costs of this, because our board cannot absorb this. I have the two different scenarios I have as far as an idea of what the world would look like. On one side, I'm getting that this is going to just allow veterinarians to do the animal blood banking within their practice. And so the thought was, if that's the case, Veterinary Medical Board already goes out to all the facilities. They're already doing the inspections. So it makes more sense to them to have the Veterinary Medical Board take that on. The other side of it is there's a belief that veterinarians aren't the ones going to be doing this, that it's going to be corporations coming and setting up their own blood banking for profit. And if that's the case and that goes throughout California, that's obviously a lot bigger scope. So those are just my concerns for the logistics of how this plays out. Whether or not the board feels this is something that the board should do, that's a policy discussion for the board. But I also provided you the letter from Assemblymember Bloom, and I believe we had copies in the back for those of you who would like to see it. He is very much interested in working with us to come up with a solution. The bill that he introduced is essentially a spot bill, a placeholder, because he wants to craft language that is the solution for everyone and protecting these animals. So with that, I'll turn it over to members and the stakeholders who came.
And by protecting these animals, you mean the donors or the animals receiving the product, or?
I think all. I think the intent is to protect, is to eliminate the closed colonies when it comes to canines. And also, they also don't want to harm all the other animals that may be impacted. I think they know that is a concern, and I think that they're open to discussing that. The governor's office is highly involved in this as well, and we are participating in a stakeholder meeting on the 5th of next month, where he has invited everybody to the governor's office to work on this issue. So,
Any comments from the board? Okay.
Where do I start? So Kathy Bowler and I have been involved with this issue because last year, and then we've continued into this year. And of course, my concern are protection of the consumer and protection of all the animals in California, but especially my own patients. And so I've looked at some of the data that I've toured UC Davis. Jessica and I just recently toured Hemopet. I've talked to the president of ABRI.
So maybe clarify Hemopet for the record, so that.
Hemopet is the closed colony in Southern California. ABRI is the Northern California closed colony. And so I learned more about dog blood banking than I ever knew before. But, as it comes to any big consideration, there's a cost-benefit ratio. And so the governor is, and many of these people are looking at the closed colonies and looking at the condition of the dogs in Southern California. I don't know more about the Northern California ones, but Jessica and I again toured Hemopet just last week. So my concern in totally closing down the closed colonies is that I don't believe, from what I've learned, that the community ones would be able to deliver the volume of blood that's needed. Right now, the closed colonies are like 6 weeks behind in their delivery of blood products. So I don't think that the community ones would be able to deliver the quantity of product. They also could not deliver the type, all the different types, and Dr. Bradbury can probably speak more to that, all the different types of blood product that are made by these commercial labs. So, we do kind of need to make a choice, and you have to choose, do we try and get these 100 greyhounds, and there were 100, these 100 greyhounds into a house, or do we try and provide a blood product that's safe, and it's available, usually, and that there's all the different types of blood products available. Well, another thing that I did just in this last week is I sat down and tried to do a cost accounting of this, because Dr. Owens from UC Davis has put forward some figures. We were in a teleconference, and he gave a dollar number of how much profit there was per donation, and it just sounded totally off to me. It didn't sound like it was possible. And so I sat down and did a cost analysis using my own hospital as a basis. I sat down with my P&L and went right through and figured out everything. And as a conservative, and I tried to approach this in a conservative manner. So I'm figuring Fresno rent, Fresno prices. And as a conservative level, the cost to the veterinarian per unit is going to triple. So therefore, there's going to be many dogs or many clients that just can't afford this. and therefore I think there's going to be dogs that are not treated. And therefore dogs that are going to die because they can't get the products they need at a reasonable price. So that's where I'm at. I appreciate where, I appreciate the groups, I appreciate their concern for these greyhounds, but realistically, where they're living right now is luxury compared to what they were on the track. Jean Jods did give us a tour of Hemopet. These dogs stay there for 18 months and then they're adopted out. There were all sorts of volunteers and staff walking them around. There's a long runway, a raceway where they can go out and play. And so I did not see the problems that were elucidated in the complaint.
Any other comments? Christina?
I guess I have really strong feelings about it just because I use so much blood in my my own practice. One patient can need 3 double units of blood in a couple day period if they have a IMHA or and so and each transfusion right now costs about $1,000 each time for various reasons. We have to cross match, we have to do all these things, but like the cost of the blood itself to the client is at least $500 for like a double unit. So if it triples, they definitely aren't going to be treated. I also worry about, as you were saying, the safe handling of the blood, how the blood's collected, the having an open colony, the infectious disease spread, all of those things. But so I think that it's really good intentions where the governor's coming from and where these people are coming from. But it's going to do a lot more harm to many more animals and people and the consumers. If we're to close these colonies altogether now, maybe there's a way to make them so that they're, that there's a difference, right, with the Hemopet versus the ABRI, where they don't adopt out their dogs, I believe. And so, there might be ways to write it so that it's not, where the animals, like that part is not allowable, where they have to find homes for their dogs and that sort of thing. But in terms of us managing it, I think that seems like a real big can of worms. And if they want to give us all of the funding, especially, and I don't think that's possible, but I even think then it would be really hard for us to do.
Well, I'm really interested in this whole subject matter because as a consumer, as a very concerned consumer, and as someone who's concerned about animal welfare, I'm looking forward to the fact that it sounds like this time with this legislation, which is a spot bill, hopefully that the goal is to get all the stakeholders together and do a very thoughtful, well-thought-out plan for the future for California and for all consumers, vets, and it's not just California, it's everywhere in the country. So I'm kind of open-minded right now. I don't want a shortage, of course. I would prefer to have more opportunities for community-based colonies. I think our current law is kind of stupid that way, but I'm looking forward to hearing everything, is basically my point.
Good. Any other comments from the board? Okay, comments from the public?
Good afternoon, Madam President and members of the board. My name is Tricia Lipper, and I'm here on behalf of Assemblymember Richard Bloom to thank you for your service and to ask you to work with him on his bill AB 1953. AB 1953 follows a similar bill AB 366, which you may recall the Assemblyman introduced last year, which sought to open a dialogue for how to address issues associated with the use of closed colony blood collection that confines donor animals to cages and kennels for months or even years. Ultimately, another bill, SB 202, passed the legislature, and that focused exclusively on permitting community blood banking for animals. But Governor Newsom vetoed that bill and instead called for the eventual phase-out of closed colony blood banking in favor of a solution that will allow for the humane treatment of donor animals. As a result, Assemblymember Bloom introduced AB 1953 earlier this month to respond to the governor's request and to move quickly to a solution. The current language of the bill is purposefully open-ended at this stage so that he can work with you and other parties to develop a workable solution. The governor's office will soon convene a stakeholder meeting to support that process, and the Assemblyman sees the board's participation as critical to a successful outcome. In closing, Assemblymember Bloom would respectfully ask that the board work with him to craft a solution that balances animal welfare and the need for safe, essential blood through voluntary community blood-based collection methods. Thank you for this opportunity to speak with you today about this really important matter.
Thank you.
Good afternoon, Chair Nolan and members of the board. My name is Shannon Keith, and I'm an attorney. I've been practicing animal welfare law for the last 20 years. I'm also the president and founder of the nonprofit Beagle Freedom Project, and we're one of the sponsoring organizations of Assembly Bill 1953 by Richard Bloom. And like all of you have expressed, and our hope is that we can all agree that there's a better way to source blood than by keeping dogs in cages for years and sometimes for the entirety of their lives. None of us want a blood shortage, but none of us, want dogs to live like this either. I don't think that is the way to go. Every single state has, besides California, has a volunteer program that has been very successful. Over the last couple of years, I've done extensive research on this. I've spoken with different veterinary clinics who have amazing volunteer programs where they source blood, and it has been so successful, not only for their practice, but it's something that brings families together. It is something that's great for the community, and it's just it is something that is just sorry, I was getting emotional about it, but it's something that is just very ethical that our state needs to look into. The transition from a closed colony to a volunteer community-based model is easily more ethical and will guarantee a larger, better blood supply. As you discussed, Hemopet and ABRI are one of the two closed colony blood banks in California. ABRI is questionable. My colleague is going to talk about ABRI. I do want to briefly talk about my experience with Hemopet. The mission of my organization, Beagle Freedom Project, is to work with laboratories to reach out to them and ask that when the animals are done with the testing, that they would release them to us so we can find forever homes for them. And in 2017, Hemopet actually responded to my letter and said that they did not need our assistance. However, after some research and speaking with some former employees and some animal rescuers, we learned that that wasn't true. So I personally visited Hemopet myself in December of 2018. I went there. It's in Garden Grove, California. I just walked in, and there's a long corridor with various doors to the left and to the right. I opened a door to the right, and I recognized what had been described to me by a former employee as the adoption room. I opened the door. I was immediately overcome with the smell of urine, feces, and ammonia. There were about 4 to 5 people walking around who looked like they might be volunteers or staffers, but it was really difficult to tell. The room was full of cages lined in rows, each with a dog. And as you know, these are all greyhounds. These are large dogs who were former racetrack dogs. They're big dogs, and they were confined in small metal crates, often with nothing in there, no enrichment whatsoever. I counted about 40 dogs in cages in that one room. However, I counted more than that in cockroaches all over that facility, in the corners, some coming out from underneath the cages that the dogs were in. I also noticed rat droppings all over that room, in the adoption room and in the medical area of that room, and in the bathroom area where the staff uses the restroom. I was able to walk around for about 5 minutes before I was approached by somebody, I believe a staffer, again, I'm not sure. They asked me who I was, and I said that I was there to visit, and I asked if I could help, and they said I could. They handed me a leash and told me to just pick a dog and go. And I was stunned. I didn't know what to do. Had no idea who these dogs were. I had no idea what their temperaments were, how to open the crates, how to approach them. I wasn't asked to show identification, sign paperwork, and had no training offered whatsoever. So I just picked a dog, opened the crate, put a leash on, and walked outside with them. I'm not sure what area you saw, but I spent a long time there, and I volunteered for a long time, and there's a small grassy area where the dogs can relieve themselves. We went outside and took a walk around. There's other buildings there, and they're all color-coded. And so what I came to learn later was that each building meant something different based on the color coding. And each building had about 50 to 75 dogs based on who they were. So some were new intakes, some were infected dogs, meaning that they had parasites like tick-borne diseases, usually coming right from the track. They had these types of issues with them. But as a volunteer, I wasn't allowed inside those buildings, however, I could walk by them. And many had some outdoor areas with a cement ground, and they had like chicken wire around them. The dogs would come outside. They all had these muzzles on them. This is a dog I adopted. Their name's Skipper, and this was the muzzle he had on. They wore these muzzles at all times. They never were without these muzzles. Always with bandages around their necks. Some with visible wounds and visible blood. In fact, always in the adoption ward, these dogs had the bandages around their necks, which I thought was strange because they were up for adoption. On top of their cages, it would say, "Hi, my name is so-and-so, and I'm up for adoption." During my tenure volunteering, which lasted from December 2018 through 2019, I volunteered about 10 times, and I adopted 2 dogs from Hemopet. I adopted Lennon, who, if you've seen some of the exposés by another animal rescue organization, he's in there a lot. He's talked about a lot in some of the complaints, and I adopted Skipper. But from the time I put in my request to adopt to the time I could actually adopt these dogs, it was several months. When I asked why it would take so long, considering they were in the adoption room, I was told this is the process. However, it was obvious that they were still being used for bleeding because the bandages were fresh. So I timed the days between the bandages. With one of the dogs, Lennon, the shortest period between blood harvesting was 8 days. So he was bled once every 8 days. The industry standard is once every 2 months. All the dogs I observed were underweight. Every single dog I observed was on prednisone. Lennon was so sick when I adopted him that I spent over $4,000 getting him rehabilitated to care for all of his skin ailments, including his weakened immune system and hypothyroidism. During my visits, I witnessed no oversight, no regular veterinarian present, and blood draws being taken by poorly trained or untrained staff who did not have prior veterinary experience. A former Hemopet employee named Diana told me that there's absolutely no training, and anyone can work there, restrain a dog for bleeding, and after a few days of being there, even, they call it bleeding, bleed a dog themselves. The bleedings, as they call them, can be so inhumane that many of the dogs pass out because these people have no training. They don't check to see if they've eaten that day, if they've had water, and they don't know how to insert the needle, and these dogs go into shock. Although Hemopet is listed as a veterinary facility, the veterinarian listed as a licensee to make it legal is not W. Gene Dodds, the owner of Hemopet, but rather it is someone by the name of Miwa Kanabi. It should be noted that this individual has never been listed on any veterinary documentation I ever saw at Hemopet. The person who has signed all of the veterinary paperwork for the dogs I adopted, and many others I've seen, is W. Gene Dodds, DVM, who is not licensed to practice veterinary medicine in California or in the United States, and who is still active online taking appointments. I am going to pass out these packages for you, which include portions of my adoption agreements with these dogs that has her name and signature as a DVM, signing their documents, as well as statements from former employees and witnesses at Hemopet. Lennon and Skipper are still recovering from the physical and psychological trauma at Hemopet, and there are hundreds, if not thousands, of more examples. Aligned with the governor's stated goals, Assemblymember Bloom shares our vision that this doesn't happen anymore. we can provide clean and safe blood in an ethical manner and copious supplies for dogs in need. So we look forward to working with the board and the profession to pursue this objective. Thank you.
I just need to clarify, I appreciate the information that you brought, but I if you have specific examples of potential unlicensed practice, I just ask that you give that to me because I need to protect the board's decision at the end if we take action. And so if you give that to me, and we can look at it in the enforcement side.
Sure. So what type of examples? What I did was I provided copies of portions of my adoption records. If there's something further you need, I'm more than happy to send that to you. I don't know if I have exactly what you would.
So I'd ask that you just hand me what you brought, and then you and I can connect after the board meeting if we need any more information.
Definitely, more than happy to.
Christina.
Hi.
Hi.
You had mentioned in the beginning that other states have successful programs where they don't have any blood shortages. Are they states that have the same volume of patients and the same number of veterinarians or anywhere close to that? And what states are you talking about?
I would have to do more research on that to compare. I know Blue Ridge is one of the big hospitals that, I spoke to that has such a great program. And so I'm happy to provide that information and do a comparison data for you and send it over to you.
Yeah, I think that would be helpful for us to see success in other states so that we have something to model off of, because really our fear, I don't want dogs living in cages and such, but our fear is that it sounds good, and I know that we had a community program at Colorado State where I was, and that was successful for that small community, but I don't know how that scales, and so that's that I'd love more information on that.
Yeah, I'd love to get it to
Okay,
you. I
yeah.
feel the same way. We definitely don't want a shortage.
Yeah,
Yeah.
thanks.
Mark?
So the conditions that you described are deplorable and should not be tolerated, but I just have a couple of questions to clarify your presentation.
Of course.
Did you say you noticed that bandages were changed every 8 days? Because you kind of implied that blood was taken every 8 days. Is what you observed that blood was taken every 8 days, or is what you observed that bandages were changed every 8 days?
That's a great question. So the bandages were only placed right after a blood draw was taken, and they were only there for the one day.
But what did you observe?
What I observed was that the bandage was on linen, and then 8 days of no bandage, and then a bandage on the
There was a new bandage on?
a new bandage.
Okay. And just anyone who graduates from a veterinary program can use the initials DVM behind their name, but they can't practice veterinary medicine without a license. That's just a point of clarification as well. So if, to Jessica's point, if you have evidence that this veterinarian is practicing without a license, then that should be submitted directly to Jessica and not to the board.
Okay, yeah. I believe that I do, but I'm not an expert in that area. So probably then what I have in this packet would not rise to that level, but I do have something else with me to show you that probably would. So.
Okay.
Could I just, could you re-clarify, when was it you were working at Hemopet? What years?
I was volunteering.
Volunteering, I'm
Yeah.
sorry, volunteering and adopting.
December, for a few months, December of 2018 through through 2019.
So through the whole of 2019,
It
at
was-
several times?
Yeah,
you
it was
went?
about 10 times.
Okay, thank you very much.
Were the conditions ever improved, like the rat droppings, the cockroaches? Was that just consistent the entire time you were volunteering?
Yeah, it was consistent. There would be different staff members and volunteers there. Sometimes they would be cleaning the floors, but there was always a filthy floor. There was always droppings, and the cockroaches were just kind of out of control.
Did you ever ask, like, are they ever going to treat for pesticides or anything, or did you?
No, because it's one of those places where, I mean, honestly, after, I went there to get information.
Right.
And I didn't want to ask too many questions.
Too many questions, yeah.
So I just kind of went about my business.
Did you videotape any of that?
I did.
Yeah. Is it on your website, or is it on?
No, I haven't, and I did do it legally. I did it on my phone.
Okay.
And I told them that I was videotaping, and they didn't seem to care. So I do have it, and I'm happy to show it.
Awesome. That'd be great.
Yeah.
I'd be interested to see it.
Sure.
Cheryl?
And then I believe after this kind of hit the news, then CDFA did a 4-month investigation and found, what did they find?
Oh, I know that
CDFA?
they did, but I mean,
Yes.
they had published a very large report.
So CDFA did a 4-month investigation and could not substantiate any of the claims that had made. And again, Jessica and I just visited last week. Now, again, they may have cleaned up since then, but we did not announce our visit. It was a surprise visit, and I did not see any of those problems.
Yeah, I mean, granted, we had, the 2 bills in 2019, and that was getting a lot of publicity with Lennon and Skipper after my volunteering, so I can only assume that things probably did get cleaned up. I hope so, after that.
Yeah, and I can say, when all of this hit, our team of inspectors did go out and do another inspection on our end and didn't find what she's describing either, so it might have been because of the work that your organization has done. I don't know if that's what did it, but I can tell you we didn't see anything similar to what's being described.
Okay, thank you.
Okay, thank you.
Yes.
Hello, my name is Frank Douglas. I work for Beagle Freedom Project, and our view is this: the reason why we don't do closed colonies with human beings, number one, is because it's unethical, it's immoral, and the actual donor would be sick after a while. And our view is, if you open this to the public, you open this to veterinarians, and you put strict regulations and guidelines of how to do this, you'll get much more blood in the long run than we have now. We're not asking for a strict shutdown of the blood coming in because there's a shortage, but we think there's a shortage because it's not in the hands of more people. And with dogs that people could bring in, like my 2 dogs are very healthy. Just like with humans, we can run we could run tests to see if they have any communicable diseases. And if it works with the human population, it's definitely going to work with the animal population. The problem we have is that these 2 companies are protected by the public records exemption of California, and there's no way to see for the public or for anyone else the conditions of what these dogs are, how they're living. And so we just want some more medical transparency that these dogs that are being used for their blood day in, day out, if it is every 8 days, which is against the veterinary guidelines, that are they carrying diseases? Do they have enough blood? Are they sick? So the problem is everyone's out in the cold when it comes to this. We kept calling ABRI, and we got an email today saying, unfortunately, the only facility we have in California is our lab and customer service. So they don't have a facility here in California. All of our donors are housed in Michigan, so you'd have a quite long drive for volunteering. Sorry we were unable to help. But the yearly California USDA inspection report by Dr. Kurt Hamill.
I'm sorry, can you just pull a little away? Thank you.
The yearly California, maybe my microphone's going out.
No, it was
Just too close, yeah.
So the yearly California USDA inspection report by Dr. Kurt Hamill. Dr. Kurt Hamill lives in Kalamazoo, Michigan. It's the California USDA inspection report that has the Dixon address here, but they don't have animals here. They have them in Michigan. So if they're in Michigan, are they under the Public Records Exemption Act of California? We just need some transparency to see how these dogs are living. That's it. Are they healthy? Is it clean? Is it a clean facility? Is there any other way to do due diligence to see if these animals are actually living the way they say they're living?
Okay, thank you.
Thank you.
Good afternoon. Susan Riggs with the ASPCA. I'm here today in a spirit of collaboration, especially given the governor's interest in the outcome of this particular issue. We believe that there's an opportunity to work collaboratively with the board and the veterinary community to get through some of the issues that you guys have raised today. Certainly the supply issue is a big one, and it was one that we actually questioned ourselves. We have veterinarians practicing in 16 states, and so when we thought about the impacts to the supply of blood to those veterinarians in other states, we got concerned as well. So we actually, polled our veterinarians, asked them, and they're, just to respond to your question, they're in New York, they're in Illinois, they're in Florida, a lot of high need communities. And so, and their resounding response was, we're not concerned. We think there's a sufficient supply of blood, and I think there's ways to work through the supply issue. I mean, certainly a phase-in is something that has been considered, where we can ensure that, that the colonies are not phased out until the supply reaches a certain level. And I think, clearly there's an issue with supply and demand here. If there's a demand for blood, the supply is going to come, and there's already been a great expression from numerous entities in the state to help source that blood in a humane manner, in a way that's safe, and certainly from the perspective of being safe blood supply, we're talking about the veterinarians that you license. And so if you don't trust the ability of the veterinarians that you're licensing to do the job well and safely, then there's a larger question on the table. So I think that that's something that needs to be considered as well. So we have this meeting coming up, stakeholder meeting in the governor's office. We really hope that, you guys will come to the table as well in a spirit of collaboration. And we want to work with you and work through the issues. They're all real issues for all of us. We're all stakeholders. So we hope that you'll work with us. Thank you.
Christine.
I just wanted, when you have the stakeholders meeting, if as we move forward in veterinary school, we're not taught how to collect and bank blood. So I didn't get that training. I did a little bit of that in my residency for a variety of reasons. But can you guys start mentioning, having that as an inclusion in the veterinary curricula and things like that? If we're going to be moving towards that, I think we need to be training people. It's just a comment more than anything. Thanks.
Good afternoon, members of the board. My name is Dr. Janine Berger, and I'm a...
Can you speak into the mic, please?
Yes, for sure. And I'm a licensed California veterinarian. I'm also one of few veterinarians that is double boarded with the with the American College of Veterinary Behaviorists, as well as with the American College of Animal Welfare. Currently, I am the vice president for the San Francisco SPCA, where I oversee all aspects of animal care. And I'm here today not because of my veterinary credentials, but I'm here today because I'm a lifelong owner of dogs, as well as I'm really an advocate for animal welfare, and this work that I'm doing is really important to me. I actually, last year, I proudly received a welfare award from the World Small Animal Veterinary Association. So I'm here today because I believe that we have an exciting opportunity to move the needle for welfare for California dogs. And I'm here on behalf of the San Francisco SPCA to express our strong desire to work with the Veterinary Medical Board to transition California closed colony blood banks to community-based models in ways that are welfare-centric, practical, and safe for all dogs, including donor dogs as well as recipient dogs. The current practice of closed colony blood banks are failing donors and recipient dogs by compromising the welfare of both of them. I think it's a perfect timing right now to make a change. National practices, accredited academic organizations such as UC Davis, and science gives us the confidence to move forward with a community-based model and reject a system that is no longer needed and not ethical. We are fortunate to have reputable local programs like UC Davis that have shown to us that community blood banks are effective, efficient, and medically safe for donors and patients alike. Proven protocols for screening, handling, and testing to ensure both product safety as well as donor welfare exist already. The welfare of recipient dogs is also compromised, and larger veterinary hospitals, for example, can financially afford to store and then dispose of unused blood products once they are expired. But this wasteful workaround is not available for smaller practices. And I know this because in addition to working at the largest nonprofit veterinary clinic in San Francisco, I also operate a smaller, private, rural community practice outside of Davis. The current situation in California is entirely unbalanced, and California can expand its pools of donors and increase the access to healthy blood products through a community model. Just one example, when the San Francisco SPCA built their hospital in 2009, they built in the capacity to have blood collection, but then learned that they were limited through the imposed state laws. But our organization is ready to jump in when we can do this again. So in closing, we all know that Governor Newsom has made his preference very clear on this issue. He says California law must lay out a framework that balances the interest of donor dogs, recipient dogs, and us veterinarians who need ready access to healthy blood supply. So I think it's up to us veterinarians, to the veterinary professionals, to rise to the occasion and to propose a viable path forward. The San Francisco SPCA is eager to make community blood banks the new standard of care in our state. And with the Veterinary Medical Board's leadership, I'm optimistic that our profession can work together to, one, transition the remaining closed colony blood banks to community models, to, second, expand safe production of life-saving blood and blood products, and maximize to achieve the welfare for all dogs, donors, and recipients alike, so that they can all have the 5 freedoms. Thank you so much for your attention.
Cheryl?
On your show first.
I don't know. I raised my hand first. Yes, thank you. Thank you very much. So one thing I would like to make clear is that no one I have talked to is against allowing community blood banks. Hemopet's not against it, ABRI is not against it, as long as the blood is as safe as the closed colonies, which means that every donation needs to be tested on a community dog. And right now, they're not, for some of them. So they mentioned Blue Ridge. I think the speaker before you mentioned Blue Ridge, and Dr. Sean Owens at Davis had mentioned Blue Ridge might want to come into California. So I called up Blue Ridge. They're in Virginia. They have 400 dogs, 400 community dogs that donate. The average dog will donate every 6 weeks. And they give them free heartworm preventative and flea products as an incentive to have, them come in and do this. They get free blood work, obviously. But they are doing blood work only once a year. They do the ACVIM consensus statement blood work that's recommended, but they only do it once a year. So I asked them, I said, well, what happens if you get a positive on your infectious disease testing? And she said, oh, we just had a Lyme disease show up. And she says, when we get those, we treat them, and then if they're not showing any signs, we just keep using them as donors. And I said, and do you do the Lyme Quant C6 test, which the veterinarians know what that is? And they said, no, it's too expensive. And I'm talking to the head person. I'm not talking to the business person. I'm talking to the head technician who's actually on the ground doing all this work. No, they don't do the Lyme Quant C6 because it's too expensive. And I said, well, do you get other things that show up positive? And she says, oh, yeah, we get positive Ehrlichia, Anaplasma, Babesia, Hemobart, we get those. And I said, well, what happens if you get a positive on those? And she says, well, we just stop using them as donors. And I said, do you go back and tell all the veterinarians who bought blood products from you, because they do ship across the country. Do you tell all the veterinarians can you trace it back and tell that veterinarian who bought that blood that it might be tainted, that it might be infected? She goes, no, we don't do that because, they sign a release saying that they know they might be buying bad blood. And I'm like, I was horrified. So I am okay with community donors, but they need to be tested on every donation. I wouldn't allow a transfusion on myself or anybody in my family that wasn't tested for HIV and all the other infectious diseases that people can get. So I'm fine as long as every donation is tested.
So what is the approximate cost currently of that ECVIM panel?
So it really varies. It depends on whether you're doing CBC and chems and all the other things too. But it's on my Dr. Owens, when Dr. Owens started to do a cost analysis, but he didn't have everything in there, like rent. And so he figured $250 per donation, so I continued with that. I checked through IDEX, and it's anywhere from like $150 to $500. There's a wide range depending upon which diseases you're testing for. Also, when the dog donates the first time, it should be checked for, it should be typed, and it should have a von Willebrand's test, but it doesn't need to have that every time. So that's also another variation.
Okay.
Yep, thank you.
Yep, Mark, I think.
Just two quick clarifications. Are you speaking on your individual, are you speaking for the San Francisco SPCA?
Yes, I'm
You
here.
represent them?
I represent the
Okay.
San Francisco SPCA, absolutely.
And has your association taken a position on AB 1953? Are you working with Bloom's office on this yet or no?
Yes, we will. And I think that's why it's so exciting, and I'm absolutely with you. And I hear, you're definitely emotionally invested in this, which I am too. And I think that's why it's so important that we as veterinarians step up, because we are the only ones that are really subject matter experts in infectious diseases and can provide for the care of our patients and are invested on a daily basis, like some of you.
Christina.
I think the point that you were making, though, does lead to us having to make some sort of, if we're doing this, and I think that we should definitely work together and try and, there's got to be a way forward. It would mean that we are regulating, and making some sort of standards of care and things for, or at least having statements about blood banking that we're going to have to come up with moving forward if we do this. The other just thing to know is that if you pool your samples, there's places like Colorado State and things like that will do less expensive pooled infectious disease screening tests. So it's just a comment.
Then if you have a positive, that will take more blood.
Yeah, it's not like, no, it's not like pooled. Like if you, large quantity, quantity.
So current prices could definitely be different.
And IDEX
Yes,
does that too.
thank you.
IDEX says.
Yes, not pooled. I apologize.
That's not gonna help us.
And IDEX does have that too. They have a volume discount.
Well, I guess, any other comments from the board? Yes, go ahead.
Well, just quickly, so this is the first time that, since I've been on the board shortly, this is also the first time that I'm hearing about it. But the three issues that, like I was writing, that came to mind was first that it seems apparent that animal welfare is being compromised. And, there's always a saying that there's truth in the gray. So even with what has been found by the Beagle by the Beagle Legal Freedom Project and what has been seen from you all, right? There's black and white, but there's always some truth in the gray. And what's to be heard is that animals are being affected in a way that we have an opportunity to do something better. And I don't hear that, we are closing, saying, oh no, we're going to close the, closed colonies at this moment. We're transitioning and we have an opportunity. Things have been done a certain way for a certain amount of time. It is very concerning also, being an attorney, that organizations are exempt from the CPRA Act. So when it comes to the fact that you are able to call someone from Blue Ridge and get information and receive all that information, we can't receive that information that's exempt from organizations that are exempt from the CPRA Act. That is, the lack of transparency should be shocking and is astounding to me. Truly, I mean, and that just comes from, I guess, also an attorney perspective of, I'm like loving the CPRA Act, there's, it also affects us at the same way. And I just don't want us to come from a place of fear of doubting that we're not going to have enough blood. Also being like, a community lawyer, there is something to be said to giving the community an opportunity to be able to give and to opening up that opportunity to the community and, not denying the community the opportunity to be able to participate in something that could be actually bigger and more beautiful than we even imagined. And also to the point of, Dr. Bradbury, to the point of that veterinarians aren't taught how to collect blood or take blood. Yes, I had no idea that was something, and that is also shocking, but it also just made me think, well then, who is being trained and taught at these places that we can't even get any records about who's being trained and taught? Right. So if I'm going to trust anybody to take blood from my dog, it's going to be a veterinarian, because I would and I guess it's also a wrong assumption of mine to have thought that y'all were trained to do that,
I should clarify. It's not that we're not trained to take blood. There's very specific protocols and collection systems and ways to do it so that it's safe and sterile, and there's good ways and bad. I mean, anybody can take the blood, but what I'm saying is there's proper ways to do it, and it isn't something. There isn't like this is what you do when you need blood donation. I don't know if anybody else had that training in vet school, like, we're going to go to the blood donation and do this.
And so I think that's why it's so great that we are all collaborating here together, and we've had and it's great that, some of our board members have gone to HemoPet, because then we can collaborate together to be able to get the best practices, to be able to learn what are going to be the best practices to transition from one to the other. But from what I've heard so far today, there's enough to pause to say, there should be a better way to do this. And if we have the opportunity to find a better way to do this, then how exciting for us to, and it is, it always is scary to change, right? Change is scary because you want to, but also change is an opportunity to make something better and to do something in a way that, yes, it's going to require more work for us, but from the short amount of time that I've been here, I'm like, I love the veterinarians. I love the veterinarians of the, and also the board. And I think that it is going to be more work, but I think it'll be far more worth it in the long run for both the veterinarians, the community, and the community and the animals.
Thank you.
Sure. Sorry. I've just learned so much about this, and it's hard to impart all my information all at once. So as somebody has mentioned, right now, with HemoPet and ABRI, they are like 6 weeks behind in orders. They're having a hard time supplying all the blood that's needed. When I have called across the country and talked to other community blood banks, a lot of these have anywhere from 10 to 20 dogs, and they are essentially just supply blood for their own hospital or maybe a few hospitals in that city. They are not able to supply that state. They're not able to supply other cities. So most of these are very small programs. So I don't, personally, from what I've learned, I don't think there's any way in the world that the community blood banks in California would able to supply all the blood needs. The other problem is that, so what Dr. Bradbury was talking about, we aren't trained to do this, and there's very specialized equipment that's needed to do this. So UC Davis has $150,000 worth of equipment that the average veterinarian does not, no veterinarian has, because it's big centrifuges that we just don't need, that we don't need in private practice. So that's a huge investment right there, and that's part of the problem of the, in the cost accounting that I did. And let's see, what was it? ABRI, the one in Northern California, they do get inspected by CDFA. I think the only thing that's really non-transparent is where they're located, and the CDFA reports, yeah. But they do get inspected by CDFA. And they do make a wide variety of products. Another point I would like to make is that, and I'm sorry Dr. Bradbury left because she could speak to this as well. As a part of all this, I hope that what we can do is to allow some other blood products that are made outside of the state that are FDA approved. Right now, they cannot legally come into California. And so we need, but like right now, Dr. Bradbury and any other veterinarian specialist or whoever wants dog albumin, they're having to use human albumin, which is not ideal. So dogs are being injured that way. But because even though the blood, dog blood originated in California, the processing for just that part, the lyophilized albumin, it's the machinery to do that, the processing to do that is outside of California. So they draw blood from the dogs in California, it gets shipped out just to do this, go through this one process for this one product, but then can't be shipped back into California. And so we need a way to be able to make some of these animal products available in California. And I think that would help relieve some of the shortage problems too.
Can I ask you a question? Because
Yes.
you were saying something about the community blood bank at UC Davis, you just mentioned it. Are they able to keep up with their needs? Or
They only supply UC Davis. No, they're not, which is a good point. So UC Davis buys products from ABRI. So they are not able to supply everything that they need.
Yes, Kathy.
Just a couple of things, because I know we're talking about this at length, which is great, but I think we're at the beginning of a process.
Yeah.
And so there's going to be so much more dialogue with experts, I hope, in a very thorough crafting of this legislation that should consider everything. And I would hope it would also consider sort of the ability for California vets, or the inability to get out-of-state products from FDA approved labs. It's kind of ridiculous that our vets are limited, and that would be great to add to the legislation and things like that. But it's also, we're still at the beginning. I think we should keep going on this. And I'll say one thing, UC Davis, we did have a really fascinating tour, and it's very well run and organized. And yes, it's for their practice only at the hospital, and certainly they have a great community of potential donors with their students, the faculty, the Davis community and everything. So they're a great sort of a ecosystem for this to be successful. And they did have to buy out-of-state products. The other side is they had products that were going to expire, and other vet practices could have bought those, but our law prohibits it. So, I mean, it's a dysfunctional system right now, and it's a very good approach that that we're all taking, I hope, together to make things a lot better for California. And we have to remember, these blood banks, from what I've read, these captive colonies are producing blood for veterinarians all over the country. So what we do here will affect the blood supply elsewhere as well, and I think that's something to be considered. So I've got great hope that we can do this together.
Thank you.
Thank you. Yes.
Hi, good afternoon, Madam President. Jennifer Fearing. I just wanted to take a moment to thank your board, and especially thank Jessica, but then thank you, Dr. Waterhouse, for all the investments of energy to try to understand this. I, too, have spent a lot of time over the last couple years involved with this effort and trying to learn everything I can with my non-veterinary practice education. But I am enthusiastic and hopeful for the opportunity to work with the profession to solve this problem. When I hear things like there's a 6-week shortage, I am deeply concerned about the status quo. Like, forget the welfare issues of closed colonies. We should not, in modern times in California, have 6 weeks, waits for blood. Most dogs that need blood need it in less than 6 weeks in order to survive whatever trauma is requiring their blood. I'm only a dog owner, but I know that much. And so we have to do something. We're currently under a very precarious, and we've been in a very precarious situation because there is no plan B. You know, if HemoPet, what if there is an actual issue with their license? What if there is a concern that rises to CDFA's enforcement to a level that they don't believe either of these entities should continue to operate? What happens then? We don't have an alternative to that. So I really feel this is an imperative that's overdue. I wish it hadn't taken advocates and activists sort of checking these out to elevate this concern, because it ought to be of concern to all dog owners, some of whom I know whose dogs have died because of an absence of blood. A friend of mine whose dog died at SacVet Surgical Services 2 years ago because blood was not available. It was sitting at Davis. And she didn't know that she could have actually apparently gone over potentially and purchased that blood separately, as if she'd signed up as a client and driven it back across the causeway. There are workarounds that some people do. People drive to other states to get blood. I mean, it's silly what we've got now. And so this really is not just silly, it's dangerous, and dogs are already perishing. So I am really grateful. The spirit that I've heard from everyone who's been involved with this at this point is that there is a willingness to figure this out and do it in a way that balances the interests of all the dogs and all the people who love them, and obviously the people who are entrusted and licensed by the state of California to make them well. So I'm grateful for this opportunity. Thank you.
Well, Mark. I call on you first.
Just a really quick question. Is Jessica or Dr. Waterhouse going to be at the stakeholders meeting next week?
Yes.
And you as well? Okay, good.
Yes.
Hi, I'm Nancy Ehrlich. I would like to ask a question about what you have posted up here. You have added F, collects blood from a dog. The way you have put it in there, it looks like only a veterinarian would be able to collect blood from a dog for the purpose of.
So I want to
blood
clarify
donation.
what's being displayed. This is the bill as it's currently written, as Assemblymember Bloom introduced it, but it was meant to be very minimal to, and essentially a placeholder, a spot bill, in order to get all of the stakeholders in. So I wouldn't encourage anybody to spend much time on what it looks like now, because I think there's more things for us to do right now.
Right, but I would encourage those people who attend those meetings to move F into C so that an RVT would be able to collect blood.
Are you going to be there next week?
Valerie Fenstermaker, CVMA, and this is just a point of clarification for what Kathy was saying. So our understanding is that no other state has a regulatory process for blood banks. And the FDA does not have an approved program. California is actually the strictest in the country, maybe because there are 2 closed colony blood banks here, but the CDFA has oversight of blood banking in California. They do, you can register with the CDFA, an out-of-state blood bank could, a community blood bank or whatever, but nobody does. So that's why you can't buy from out of state, because if you aren't registered with CDFA, you're prohibited from doing that. So that was just a clarification from you. If you open it all up, whatever our regulations are, will continue to exist and be consistent for all of the veterinary purchases that are from California. So this, yes, it does cross over through the whole country, but our state is actually at a much higher standard throughout the nation. So, anyway, just a point of clarification.
Thank you.
Okay, any other public comment? So I would just say that I think that this is a great opportunity to collaborate, and I think that, as you heard, the board is very vested. I know we sometimes sound like negative Nellies, but I think part of it is because we really do take consumer protection very seriously, and so sometimes that hat makes us like worrisome parents, so to speak, in my opinion. But I think we all want effective, safe, and humanely collected, blood products. I guess one of my questions is I hear on and on about we don't want dogs confined in cages, and I kind of catch on that because I can't remember a humane, any shelter that I've been in that dogs weren't confined in some manner, right? And maybe there's obviously white lines to that, but it almost opens up a bigger picture to me of why haven't we really talked about changing regulations for closed colonies if they're safe products to have a humane environment for those donor dogs? I'm just wondering why we don't also put that on the table, because it seems to me that there might be some immediate changes we could make in regulating closed colonies so they could still provide a safe and reasonably priced product, but the dogs would have a humane existence. So those are just some of my thoughts. But we as a board, I think, are very interested in being a part of the dialogue moving forward, and I'm sure we will be. So thank you so much for coming. I apologize for pushing you to almost the end of the day. You were very patient, and I appreciate that. I know that's tedious to listen to everything else, to have something to say. So I guess anything else that... Okay, well, let's move on to...
So we're going to actually skip AB 228. There was some discussions that's being had about changing the statutes regulating industrial hemp, but those have not come to fruition yet. I just wanted to put it there in case it did. So we're going to skip that. SB 627 has not changed since the last board meeting, but again, I wanted it as a placeholder to discuss. We do have someone from Lovingly Legally here, so perhaps she can provide more input of what the status of SB 627 is.
Is this on? It is on. Thank you very much. Susan Tibbin, Lovingly and Legally, sponsor of SB 627. Paul Hansberry apologizes for his absence, and that goes to what's happening with the bill now. He is meeting right now with the author and her staff. But we do have a couple of comments. Chair Noland, board staff, we really sincerely thank you for working with us all this time to shepherd 627. As a member of a number of boards myself, we truly appreciate your hard work, and we recognize it and appreciate it. 627 was written in part to rectify a current situation. Well-meaning and sometimes less than well-meaning pet owners are willy-nilly going to recreational dispensaries, interacting with counter personnel, bud tenders, for cannabis products and using these products on their pets. And so we ask you to consider if a person over 21 years of age goes to purchase cannabis products from an adult use, a recreational retail outlet, without a doctor's recommendation for medicinal use on a child, is that okay? If it is, why? If it isn't, why? And so if we look at the same scenario, a person over 21 years of age purchasing a cannabis product from a retail outlet, a recreational outlet, without a doctor's recommendation for medicinal use on a pet, is that okay? And if so, why? And if it's not okay, why? It begs the question, is medical cannabis for pets to be in a medical cannabis dispensary, or are we going to continue this sort of quasi-recreational use of cannabis for pets? And as you so eloquently stated earlier, and I'm not sure if it was you, Chair Noland, but it was very eloquent, the mission is consumer protection and protection of the animal patient. Remember that the veterinarian's recommendation is a beautiful cornerstone of 627, but without medical cannabis being restricted to a medical cannabis dispensary, it's optional. And we continue the present situation that we've outlined. We urge the board, as we move forward, to weigh in with respect to medical cannabis being in a medical cannabis dispensary, not recreational. Let's make the veterinarian's recommendation carry the weight that it should, and let's adhere to consumer protection and protection of the animal patient. In terms of you weighing in, we are somewhat lay people in terms of legislation, and so we would ask that you weigh in perhaps with the author's staff, and any other bodies that you feel would be appropriate. But as medical professionals, I think you get it. We do not want to see what's been going on for quite some time continue to go on. It's just unsafe, and it's not the mission of all of us. So thank you very much. And is there a question?
I do have a question, thank you. As you can recall from the prior board meetings, one of the biggest concerns that the board had was the lack of funding for animal research. At the prior meeting, we had presented some amendments that we would like to see happen that would do the carve out for funding specific to animal research, because right now it's not specific. Since it's not specific, all of that money is going for human research. And as I recall at that time, you were both open to that and didn't see an issue with that. So in the conversations that are happening now with 627, is that still something that you're willing to consider accepting in the next version?
Thank you for bringing that up, and that is part of the reason that Paul is meeting right now with the author and staff. One of the reasons that 627 became a 2-year bill, if you remember, at the nth hour, we were presented with quite a number of takeaways. And the thinking was that by accepting them at the time and making it a 2-year bill, we would be able to go back and negotiate and get some of those takeaways back. And the research is right at the top of the list. I have no definitive answer for you right now.
Okay, thanks.
But we, of course, supported it. That's one of the things that was supposed to be in there, yes. Thank you very much.
Okay, Dr. Nunez.
I really appreciate that first point about where these products that are meant to be used on animals can be sold. Because, for example, and I really do mean this when I say it, recently I went to a marijuana dispensary place with a friend who was going to buy something, okay? I wasn't going there for myself. I really did go with a friend because I wanted to ask the bud tender.
Could everyone else see the friend?
Because I wanted to ask the bud tender. I said, hey, do you have anything for pets? Because I really wanted to know what they said.
Yeah.
And they said, oh yeah, and they just brought out all these different products. And I said, what can I use these products for? And they listed a whole bunch of conditions that these products could be useful for. And then I said, is there any reason why I shouldn't use them, or is there any contradictions? And oh no, it's completely and totally safe for everything. And so I did a little research, and so this point about, maybe not having these products available in the recreational dispensaries, but only in the medical dispensaries, I support that idea. With the provision that it doesn't make it overly restrictive for these products to be obtained if there truly is a medical need for it.
Thank you, Dr. Nunez. And if I may ask just a little bit of patience from the chair, the brief answer to that, we call that availability. We don't want to restrict availability. And what's interesting is in the state of California, not only do we have many areas, many counties or areas of counties where the restrictions are such that there is no recreational whatsoever. However, if we do the numbers, we have more medical cannabis dispensaries in the state of California than recreational. So access or availability is really not an issue. Thank you.
I didn't know that.
Sure. Thank you. So is your intent of this, of 627, is your intent to allow the use of CBD only? Or other cannabis cannabis products too?
That's an interesting question. And it deserves a longer answer, but I'll try and do a quick answer. For cannabis-based medicine to be effective, and I'm drawing on my decades of work as an herbalist, as well as all of the anecdotal information that we're privy to, as well as all of the abstracts, primarily from the Nordic countries, Great Britain, and Spain. We know that isolates are not effective. They are not effective for human conditions, and they are not effective for animal conditions. So when we look at isolating out a particular part of the plant, THC, CBD, a particular terpene, we know that those are ineffective. So when you ask if we're countenancing products that are only CBD, we don't really countenance any products in particular. What we countenance are products that are called whole plant, where the various parts of the plant work synergistically. In abstracts, it's referred to as the entourage effect. So, for instance, if we reference a human medicine, which we're all familiar with, called, and I'll probably mispronounce it, Epilodex, which was 2 years ago, the FDA approved that for various kinds of childhood epilepsy, which was very difficult to treat. Epilodex does have some psychoactive effects. They're very, very mild, but it is not an isolate. It's not just CBD. It's a whole plant extract. It's made by GW Pharmaceuticals. Actually, GW Pharmaceuticals is their product is slightly different than Epilodex, but in terms of whole plant, they're similar. So that's a much longer answer than I wanted it to be. And truthfully, that's not our area right now. If there's a medical cannabis medicine that's going to work to ease the pain of, say, a hip dysplasia, and it's an isolate of CBD only, then we countenance that. Our experience tells us that it needs to be whole plant, and there needs to be probably some THC, as well as all the other aspects of the plant. There are about 60 different aspects that work together.
And I think it's Epidiolex.
Thank you. Thanks. And thank you.
I would just like to add, as I did at a meeting 2 meetings ago, I think that most products meant for veterinary use come from industrial hemp, which is less than 0.3% THC on a dry matter basis. The primary molecule in those products is CBD. But it is most of those products, the good ones, are whole plant products, but they come from hemp. So they don't have high levels of THC. And you don't have to go to a dispensary to buy them. You can buy them online.
Okay. Moving right along. All right, so D, we can skip as well because there hasn't been legislation introduced regarding our sunset bill. So that moves us to 12. Let me unlock my computer. Sorry. Okay, so in an effort to evaluate all our processes and streamline and save costs, how we are have the procedure for issuing and contesting a citation I felt needed to be updated. So the first one that I discuss is 4875.2. I think the first thing to keep in mind is when I first saw this, I was kind of shocked at this uniqueness to this board. It is very much duplicative of what already exists for due process. And it also requires an expert, a veterinarian expert involved in every single case where we want to issue a citation. While the statute gives me authority to issue a citation, I can't issue a citation until a licensee who is also an active market participant tells me essentially that I can. I think that there is so many steps and statutes governing due process, and I think that a lot of this, the intent is to make sure that everyone has the opportunity to be heard and to contest if a citation is issued. I think that there are various statutes already in place. And I also think there's a lot of violations that we can should be able to issue a citation for without having to contract with a subject matter expert in those cases. That will significantly delay citations, and they're just not necessary when we're not talking about standard of care type violations. So we're looking at if we're able to issue a citation for convictions that have nothing to do with the care being provided. Again, if we're able to issue citations for CEs, that's not stuff that we need a subject matter expert to opine on. It's very costly, and it delays the time frame. I do feel like we are adequately covered with striking the most of that language. Again, I even double checked with Tara to research if there is any other board with any similar language, and there's not. I think that we are not in any way cutting back due process with these changes. It's just making it a lot more clear, and it's allowing us to streamline the citation process itself. So that's the first section that we're referring to. The second section that we're referring to actually was brought to our attention by Bonnie Lutz and her team because it talks about the procedures for contesting the citation. It's conflicting with Business and Professional Code 125.9. It really confuses the subject as far as how long an individual has to notify the board of if they want to contest it, and then request an informal conference, and it really confuses the matter. And so Tara has graciously provided us an example, and I believe it came from Architects Board, of a better way to propose a better solution that would not contradict what's already in another section. So with that, I'll open it to questions or.
I have a question of clarification, and you're hoping to put this in the sunset bill?
Yes, thank you. Because it is going to streamline the process, I think, and it will save a substantial amount of money and time and enforcement. And given the fact that those are all things that we need to be looking at, I think it's a good time to ask that this is included in the sunset bill, and that way it's enacted quicker.
Okay. Kathy?
Actually, ironically, our current process, I mean, removing the licensed active market practitioner in the oversight of your decision to do a citation is actually probably better in light of the North Carolina State Board case, given the fact that that was part of it, was restricting, not trade, but practice. So that actually makes sense, and I would assume that's something that would be, I mean, this is not controversial per se, and that also would add to the legislative concern about North Carolina for all our boards. This might be a way to make us a little bit more immune to any issues. just because of removing, if I'm understanding you right, you needed a licensed practitioner to approve.
Right.
A site prior to this. And this way, the staff would be issuing it.
Yeah.
Okay, thank you.
Notice I
Do we
looked
need
at your-
to,
I looked in your direction first.
Do we need to, do we need to have, I mean, who's going to be in the informal conference? I assume it's the enforcement manager and the executive officer?
Yeah, so it's always going to be the executive officer, the enforcement manager, if available, but always the analyst who's also the one who worked the entire case. And then depending on the other side, the respondent, and then the respondent's attorney.
So it is what I assumed it is going to be. Does that need to be clarified, or there's no need for that?
I don't think so. It's because, again, the informal conference is part of the whole due process that's already existing.
Okay.
Okay. Any comments by the public?
Bonnie Lutz, just really quickly, I'm actually really happy to see this because those two statutes were ridiculous to follow and they contradicted themselves. I just want to clarify one thing though, and that's in the new 4875.6A. It does say, in addition to requesting an administrative hearing, you can request an informal conference. Well, the old 4875.2, basically, if you read it the way we read it, said that you had to request the informal conference first, and then basically if you lost at the informal conference, you could request a hearing. That seemed to make sense to us. It worked really well. I've done a lot of informal conferences. I think they're really helpful. I just don't know if we want to clarify, because I do have clients who come to me and say, you know, my friend is an MD and he says I don't have to do this informal conference, I can just request a hearing. I'd rather not do that for two reasons. Number one, obviously it's a cost to you, but from my perspective, it sets it off way, you know, it could be 2 years before you ever get to the hearing. So is there a way to just clarify, because I know it's clarified later. In D, it does say that if you go to the informal conference and then you're basically not happy with the result, you can request a formal hearing. What I'm concerned about is the first sentence in 4875.6A, which says, in addition to requesting an administrative hearing.
Yeah, it's a good point. My concern is if we require them to do an informal conference before going to administrative hearing, it's actually contradicting the APA. I'm not 100% positive on that, but I know at my former board, that was the main reason why we had to do both, because the APA allows for them to do a hearing. So if they don't want to do an informal conference, they didn't have to do an informal conference.
Okay, I just really needed clarification. I will still recommend that my clients do an informal conference, but.
Thank you, I appreciate that.
So I want to clarify that in 4875.6, this is just making sure that people don't feel that they have to do the informal conference. But it's also inclusionary that 125.9 says you can get your, appeal, you can get your hearing, but you can also do this informal conference. And because of the time frame, both are now set to be 30 days from issuance. So if you wanted an informal conference, and/or a hearing, you would have to request both at the same time.
Okay, but.
One or the other or both.
Well, that's
within
not
30
really what it
days.
says in 4875.6D. Because 4875.6D says that if it's affirmed, if you go to the informal conference and the citation is affirmed, then the respondent may make a request for a hearing.
Right, and you see the process there.
At the same time.
But it starts out, citation is issued.
Right.
You can do one or both of two things within 30 days. Request your informal conference or request a hearing, or both. That D only speaks to you requested your informal conference and you don't like that decision, you still have the ability to request the hearing. So it's linear It's
Right, I
not one or
understand,
the
and I
other.
just wanted to make sure that that was still the
Yep.
case, because that's how we've operated. It's unlikely we request both within the 30 days, because we'd rather go to the informal conference first.
I've seen it, but.
Thank you.
So unless Bonnie would like the honor, I would like to motion to approve the attached legislative proposal for inclusion in the Sunset Bill.
Is there specific wording we need to read?
No.
That'll do it. Okay, do we hear a second? Second. Okay, a second. Any more discussion from the board? Any more comments from the public? Okay, call for the vote.
Ms. Bowler?
Yes.
Dr. Bradbury? Oh, sorry, who's left? Dr. Nunez?
Yes, and good job, Jessica.
Thank you. Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Yes.
Dr. Noland?
Yes.
Thank you. And my enforcement team thanks you as well.
We're so appreciative of this. Okay, what's next?
All right.
Number 13 now. Just a clarification, Jessica, we passed by 11D because we are,
Right, so that was a placeholder if legislation was introduced for our
Got it.
sunset bill, and since it wasn't introduced yet, we can
I
keep going.
understand, sorry, okay. Now we're on item 13 on the agenda.
So, members, before you is a significant amount of information from AAVSB, and so we can take these in order. 13A is a call for bylaws amendments. This is something that AAVSB does annually, and so they asked for those amendments. If the board has any, so I wanted to provide them to you, and if you do have them, please let me know, and we can bring that to their attention.
Did anyone, in reading through there, wanted to make any
On amendments, I
amendments?
don't, I have nothing.
Okay.
Okay.
So then, my next one is the proposed model regulations regarding appropriate use of opioids and other controlled substances. I have to clarify that I put in proposed amendments for both B and C. They're not actually amendments, they're new models. So the first one is the proposed model regulations regarding appropriate use of opioids and other controlled substances. I just want to, with anything that AAVSB puts out, I just need it to be clear that a lot of times we hear back, they're just guidelines, and the states can do whatever they want with them. But we've seen firsthand of just guidelines, that comment coming back when we are doing something contrary to what the rest of AAVSB is doing and they put out as a national example. We had telemedicine, for example. We did something contrary to what AAVSB had put out, and that was a comment that came back to us during the rulemaking was why were we doing something different from the national standard from AAVSB. So the comment that these are just guidelines doesn't play out well. So if the board does have comments or concerns, then I think it's important for this board to share those with AAVSB as soon as possible.
Okay. Any comments, or Kathy?
Well, I know, Dr. Sullivan just left, but I thought he was involved in, I know compounding, but I also thought it was in the opioid drafting as well.
That was with the AVMA, not the AAVSB.
Oh, okay, sorry about that. But Jessica's correct. Even though these are templates nationally, sometimes they come back to haunt us on the state level. But I don't know enough about subject matter,
So we're being asked to
or Tara has.
speak on the language of what's in front of us, correct?
Yes.
Okay. And so I would be concerned about Section 7, about having to report any theft or loss of scheduled drugs to the board.
Can you speak closer to the mic?
Sorry. Do we really want to get reports of stolen controlled drugs? So section 7 on page 9. Whenever theft or unusual loss of scheduled drugs shall be reported to the Board of Veterinary Medicine.
Okay.
Do we really want to have those reports here? They don't come in now, do they?
No, I think they go to
I don't- that's really-
DOJ
it
as
should go
well
to-
as DEA, but Tara, you're
My
right.
understanding is they get reported to the DEA and then whatever your local police.
Right.
Oh, yeah.
Another interesting fact, so I was on the webinar from AAVSB, and in the state of Virginia, gabapentin is a controlled drug.
Really?
So it may be coming down the pike for us too.
Any other comments? Looks like we have a public comment, Sue.
Sue Gernon, just a public comment on the history of AAVSB. I was a former EO to the board, so. AAVSB's model guidelines were based on California's Practice Act. So, and they were designed to help smaller boards that didn't have the resources with their own Practice Act. So it's kind of shocking that it would be used against California, but I could see how that could happen. So, but whoever's your AAVSB rep should say, well, what you should model it. If it's changes in California, then it should be reciprocated in the guidelines, because the original ones were based on our Practice Act. Just FYI.
Thank you.
Thank you.
You know, it's too bad we don't have someone on the inside at AAVSB.
Yeah, we sure tried.
Yeah.
Yeah, we did. But I think there's an opening again this year. We're coming to it,
Yeah.
right?
Anybody, any other comments on
nominate.
this? I have a few if you guys are done. I think it's hard to, I think we ought to say something about the XXs in here because they're, they're, I think we ought to have some opinion about them. If you'll notice on, there are several of them, but page 6, I think it is, they said the initial dose shall not exceed XX days supply. Down below, and G, it says the controlled substance beyond XX days. So there's an XX months and I. And then I also had a question about the section 2 on page 7. The AAVSB recommends that for the continued prescribing of opioids, et cetera, the patient should be seen and reevaluated at least every 6 months, which seems a bit arbitrary to me. Not sure we want that as,
I think
maybe should be a lot more often, or it should be maybe it doesn't need to be until every year.
I
In
think
other
it's
words-
because the prescription for controlled drugs is only good for 6 months, right? Yeah.
But again, I think that's on a case-by-case basis.
Yes.
I get worried about them putting a blanket, figure there, but that's just me. Yes.
I was just going to add to what Dr. Waterhouse just said, that for the human world, I'm a pharmacy technician as well, controlled drug prescriptions are every 6 months. You have to get them renewed, you have to go again. You can't just have an automatic call-in. So she was kind of, was leading there, and I just want to expand upon that seems like maybe borrowed from the human side.
Yeah. Anything else on this one?
Okay, so with this one, since we do have recommended concerns to raise, and it was both from Dr. Waterhouse and Dr. Noland, I asked that I can draft it and then send it to the two of you to approve what is being sent.
Okay. There is a time constraint here. I think it's February 28th.
Right, which
or
is why I
20th.
wanted
Yeah,
to
okay.
do it quickly.
Okay, thanks.
Okay, C is something similar, but they're creating new regulations regarding scope of practice for veterinary technicians and veterinary technologists. So is there any input the board would like to provide to AAVSB regarding the document?
I was quiet this morning, now I have all my questions. So on page 5, it says there's statute change in at least one jurisdiction to recognize the difference between a technician and a technologist. Do we know where that is? Missouri. Okay. which jurisdiction has differentiated technician from technologist? I lived in Missouri for 4 years. It surprises me.
So I'm not hearing any concerns or any input to provide.
I assume this is down the road, they're going to be asking for different job duties for these two. That's what will happen, my prediction. But I have no problem with different titles. What do the RVTs think?
I think, to be fair, we haven't discussed this issue, technician versus technologist. But in terms of these job tasks, I think way back when, in the 70s, when we were determining job tasks in California, we started off with lists like this. And then it became unwieldy, and we ended up shortening the list a great deal to only the tasks that we have now. And anything that was not listed under direct supervision could be done under indirect supervision. So they didn't need to have a whole list of tasks under indirect supervision. And we, of course, don't have any tasks under immediate supervision. It seems pretty obvious that surgical assistance to a veterinarian would be done with the veterinarian right there. I mean, it seems ridiculous that you even need to mention that. And they put this as an RVT job task. I would imagine that veterinary assistants are also assisting veterinarians during surgery. And so this would make it restricted to only an RVT could assist a vet. I presume that's what they mean. I mean, they didn't say that these are tasks only for veterinary technicians and technologists. But that's the way we have it in our Practice Act, that the job tasks that we list out for RVTs are restricted to RVTs. So this is a bit confusing, and I think there's too many job tasks listed. And some of the list of things that they have under direct, we allow under indirect. Some of the things that
And that was when I first read this, that was my initial confusion and sort of concern is it really muddies the water a bit, and, when they become so detailed. I do like the first model regulation paragraph, which is very clear about, it's still ultimately the veterinarian who needs to decide the competency of the licensee and whatnot, but it gets a little, it's a little muddy to me, but anyway, sorry. Thank you, Nancy.
I think they're going to run into trouble in several jurisdictions when they try to put the, like they say, like Jessica said, it's guidelines, right? It's not nothing, they're not telling a jurisdiction they have to do this. There are jurisdictions like New York, like Virginia, that have much more restrictive job tasks that are restricted to RVTs only, that they are running into problems because there's a major shortage everywhere of credentialed technicians. So that's a big problem. You guys asked about differentiating in the statute between technologists and technicians and whether or not there might be, cut down the line, a further differentiation of job tasks. And if I recall, last year or the year before, we actually tried to expand job tasks for RVTs in California to include some of the things that aren't even on here that I think are much more dangerous that really should be restricted. The other thing that isn't included in this proposed guidelines is any mention of veterinary technician specialists or their specialized knowledge or training that is far advanced from RVT licensees or veterinary technologists. So I'm not sure if I don't know how many VTSs there are in the state of California. I don't know if that's something that we want to provide to the AAVSB. I know NAVTA is doing a webinar to ask for input from NAVTA members about their input into these guidelines as well. So I'm guessing that there will be some changes maybe down the road.
Would it be appropriate in a letter from us with some cautionary about this and say, this is different than what we do, and plus the more restrictive and you get, it could cause problems, something that we're concerned about?
Yeah, and I also would encourage CARB to do the same, to send in your concerns with the model guidelines as well.
And I like the idea of mentioning the specialists, and they're not even addressed.
I think we're at a point now in the evolution of our side of the profession where it has become, I mean, there are somewhere north of 1,100 specialists, VTSs in the world. So we're not common, but I think we're becoming more and more common as time goes on. So I do think we may be hitting that time where it's time to start addressing that in these kinds of guidelines and possibly even in practice acts as well.
I just want a point of clarification. This list here on page 6, it says allowable healthcare task. That's different than a restricted healthcare task, right?
Well, in essence, but has direct. In essence, you could read it as everything else is restricted. It's muddy. It's very, in my opinion, it's not very well.
I wonder if we could perhaps introduce our Practice Act and see if they can model their Practice Act after our practice.
We could certainly
Back in the
suggest
days
it.
when America was great.
Although I would love to include some additional
California
tasks
was
in
great.
our practice act
When
as well.
California was great, I meant to say.
But I would love to expand the list that we have right now. But that's a different issue. Yes.
Yeah.
Thank you.
Thank you. So again, I think, are we going to rely on a letter?
Yeah.
Okay. Who would you like to have look at that letter?
Who would like to look at that letter?
Who would like to look at that letter?
Well, how about Jennifer Laredo?
Would like to look at
Jennifer
that.
Laredo's not here, so let's put it to her.
Good idea, Mark.
And Mark is volunteering himself. I can just read it in his,
I'll do
body
it, I'll do
language.
it with Jennifer. Jennifer and I.
Yes, okay, perfect. Okay, we're doing well.
Leadership.
Okay, so D is a resolution 2019-1 regarding regular submission of licensee data. I think that we're ahead of the curve on this one because we're working closely with AAVSB to deliver this through a interface between our two systems. There's a lot of boards out there in the U.S. who are saying that they just don't have the resources to report this information. They're really concerned. They're not regularly doing it. And this is something that once we implement it, AAVSB will be able to encourage more boards to implement it as well because it's a really important piece that needs to be put in place for AVSB when it comes to license information across all boards. So there's no action, it's just giving you an update. This is the resolution, but we are doing this already, and it's going to be amazing once it's in place. The next one is
And can I add one thing?
sorry, yes.
The AAVSB is using this as a model for all the boards to make a simplified process for all the boards, which will in fact help us tremendously in getting data from jurisdictions across the country and Canada. So that's great.
All right, E, nominations for 2021 leadership positions. There are some positions that are open on the board, as you recall, at the last round of nominations. We did nominate Dr. Nunez, and unfortunately was not successful. But I would encourage nominating individuals. Again, I think it's very important that we have an active voice on this board.
Cheryl,
I nominate Dr. Nunez.
for a directorship position,
For
or
a
should we go right for
directorship
the presidency?
Directorship.
Do we have a second?
Second.
Okay.
And then I presume the same
Dr.
rules will be that.
Nunez, do you accept these
Oh, yeah, I
nominations?
forgot about that.
Yes.
So this is,
We
and
do-
there are certain things that you need to provide, right? From
Yep.
Dr., and get from Dr.
And
Nunez.
there's the date
The
of May
CV.
28th for the final packet.
Okay.
Okay. Public comment?
Any other comment from the board? Public comment? Are we going to vote on this then?
Yeah.
Okay. Call for the roll.
Ms. Bowler?
Yes.
Dr. Bradbury? Oh, I hear it. Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Ms. Yanis?
Ms. Yanis?
Ms. Ennis? Yes. Dr. Noland?
A resounding yes.
Okay, motion carried.
I have something I want to bring up there.
Yeah.
Can I mention on page, no, I can't find it. I'm going to get to it. Oh, maybe you're going to get there, but I'm actually looking at the legal counsel funding program. Are we going to go there?
That's my next item.
Okay, I'm ahead of you.
So, Legal Counsel Funding Program, this is a new program by AAVSB. They will fully fund attorneys, board attorneys to attend as well. They are limiting it to the first 10.
Yes.
And so I think it's a great idea. I have been not only to AAVSB, but other other similar meetings, and oftentimes it's a one-sided attorney who is presenting, and I think it's really important to have our legal counsel there. And so knowing it was limited to the top 10, I did throw our name in, but I can.
That was my question.
I can withdraw it if the board doesn't want to, or Tara doesn't want to, but I wanted to make sure that we had our spot. I know that there's might be some concerns from the legal office. There might, but also there's an approval process when you travel out of state. Regardless of funding, you have to get approval from agency and the governor's office as well.
Where's the next
Typically
meeting?
Portland.
Oregon.
Okay, so
good.
we're not
It's in
there.
Portland.
Yeah, it's
It's
not a
not a
bad.
forbidden
But you
state.
still have to get approval to travel out of state, and that's typically done a year ahead of time. So we would just have to work to get that through if the board would like it and if Tara accepts.
Mark,
I motion that we send Tara to Portland.
I second that motion. Question, Jessica. Were you able to interpret prior to the published registration deadline? Was there a published registration deadline in this wording that?
I don't
know what that means?
No. Registration deadline, that's for when you register for
the conference.
the conference.
Okay.
And that's
Yeah.
not for a
So
while.
have you had any feedback from the AAVSB on your timeliness of your application?
She just said she's going to add me to the queue. I don't know where I fall in the queue, but as soon as I got it,
Yeah, it might be, if we go ahead and approve this, it might be prudent to find out before we go through the processing whether she's made it or not. Any other comments from the board?
we probably want Tara's thoughts on it.
Tara, do you accept this nomination?
I accept the nomination, and then
You will
it is
serve.
subject to my supervisor and deputy director approval.
Yeah.
Okay.
And we'll find out if you're on the list prior to that. Okay. Any public, sorry, yes.
I was just going to say that I hope that the AAVSB takes advantage of this opportunity, because I think California is a unique animal, so to speak, within all these boards and jurisdictions, in that we are more highly regulated. We have a huge base of consumers and licensees, and our, legal regimes are so much more, in many cases, more complex than a lot of these other boards and jurisdictions that I've found in the last few years of being on the AAVSB in their sphere. And so I think Tara would really offer a lot of assistance and a great wealth of information. So.
Jessica, was this a written, did you submit a written request?
I did.
Okay. We could also send a letter suggesting or inviting Tara to be involved in some part of the program.
She didn't accept that one.
If she gets accepted, she can
You
actually.
should have seen her face.
But I think as Kathy said, she has a lot to offer. Okay.
The title of your
Any
presentation.
comment from the public?
Well, actually, we had the motion in a second, so I just want, sorry, do you have a comment? Sorry.
I think all the board commented. Any public comment? Okay, so call
Okay.
for the roll.
Ms. Bowler?
Yes.
Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Dr. Yanis? I'm sorry, Ms. Yanis?
You got promoted.
Wow.
Dr. Noland?
Yes.
Motion carries.
We're getting
So the last thing, we just quickly to go back to agenda item 9. Do you want to just share?
Can I
what-
ask a
or-
quick question
Yeah.
while we're on AVSB?
Sure.
One thing that would help my candidacy is a committee position, and I submitted a request to be placed on a committee at the last AVSB meeting. I haven't heard anything back, and I thought you were, did you talk to the executive officer?
So I did email them, and at the time, they weren't able to get back to me, but they did call me and leave a voicemail and tell me that they're calling to talk about it, but they didn't respond to my email. But since then, I haven't had a chance to reach back out to them to
Okay.
find out what happened.
Okay.
Because I think Dr. Noland and I both volunteered to be on more committees too, and we did not get, I'm still on the executive director committee, but we didn't get responses on anything else.
Weren't feeling the love, yeah. Didn't feel any love on that one.
Any committee will be fine.
So as we move on to this last item and actually go back to this last item, I'm going to just jump in, and I really believe that we did a very good job of trying to identify every possible strategic goal that we could in our session, and I thought we really were very thorough in doing that. But it's my opinion that this is just impossible for us to really focus on what's important with this. And so I would like to suggest, of course, we'll open it to comment and whatnot, but my thought is that we actually get a subcommittee put together that could spend some time with these, and that could actually consolidate some of them and spend time looking at some some reasoning behind priorities for these. Actually, Dr. Bradbury indicated to me she would be interested in helping with that, but I know she's gone now, so she's not, so we can actually volunteer her in absentia. But, so anyway, as I read through these, I feel like it's really, it's impossible for us to direct our EO and staff to do all of these. It's not realistic. Okay, Mark.
Deadline?
So there's not a set deadline for a strategic plan. It's a document that evolves, that is generally 4 years. Our last strategic plan has expired, so it's never good. It's not a great idea to operate an extended period of time without a strategic plan. But I think that taking this approach is a lot more thoughtful than pushing this one through, because I don't think the current one is realistic. So I think it's a better approach to reevaluate it back in April.
Would it be detrimental not to have it in place by our sunset review process?
I don't think so. I think that we can explain that. It's really the board recognizes all of these issues and wants to tackle them all now. I think it's showing that the board is really interested in making sure that things are improved.
Okay.
But I don't think it's going to be a sunset issue.
I have a comment about that, too. We could actually flip that around, and in some ways, the comments and the concerns that we pick up during our sunset review process might better help us to focus on our goals. So we could actually turn that around and use their input to help us.
Okay. So now, who wants to do it?
Dr. Bradbury volunteered in absentia, so she's on the list. Anyone like to help her to actually work on this project?
I can get one more.
Yes, only one more.
Well,
I think Mark should do it.
I'll work with her.
That's 2 committees. You're good with that?
yeah, that's true.
The first one's not that difficult.
AAVSB might not want you on committee, but we do.
Yes, we want you on that committee.
Okay, thank you.
Thanks,
So we will
Mark.
have Dr. Bradbury and Dr. Nunez take a look at these with the goal of trying to consolidate them where appropriate and to come up with some reasonings for stratifying them or for actually prioritizing them. Is that a motion?
No.
Okay, good. Okay. And then we'll look forward to your report in April.
Next week.
Next week. Okay.
Okay, we're done.
Okay, I think we did actually get through the agenda. And I'm going to go ahead and call this meeting to
Recess.
recess until tomorrow morning at 9 a.m.
Yep.
Thank you.